Yes, Your Lordship. I beg to mention item number 10.
Item number 10.
Yes, Your Lordship. When given us 4 weeks time to file a reply.
You are for the petitioner?
Yes, Your Lordship.
Okay, Miss.
And so,
Absolute and Council of petitioner has prayed for and is granted how much time?
4 weeks, Your Lordship.
4 weeks time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Okay,
Your Lordship, there is an interim.
the interim order, if passed earlier, if any, shall continue till the next date of listing. Yes.
Yeah, please, Lordship. Lordship, item number 12. Lordship, this morning only I received instructions, so kindly grant me 3 weeks of time to file my affidavit. Lordship, I have no objections.
Okay, Mr. Senti Iyengar, Learned Counsel for the petitioner is present. Mr.
Ajungli, Lordship.
Arjun Learned State Council has submitted that he has received the necessary instructions to file counter affidavit on behalf of the state respondents and has thus prayed for how much time?
Lordship, 3 weeks.
3 weeks time to file counter affidavit. The prayer is allowed to list the case after 2 weeks on the date to it expired office.
That's all right. Lordship, simple prayer. On behalf of Indian Song, additional HA, Lordship. Item number 2.
Item
Yeah.
number 2.
Lordship.
Okay.
Lordship, there are no objections.
Why?
Lordship, they have been taking the same prayer since last year.
Let us see how many time.
If a last opportunity can be given them.
When the notice was issued.
Last September.
Long order.
The petition was filed on 13th September
Yes.
2024.
About 1 year.
This Lordship.
Yes. On the 30th September, you said that you'll file a comprehensive affidavit. File within next 4 weeks.
3 weeks, Lordship.
3 weeks.
Lordship.
As the last one.
Lordship.
Okay. Mr. Santiago and counsel for the petitioner is present. And Mr. Ajungla, Land Council, State Council on representing Mr.
General Lordship. Behalf of
Learned Additional Advocate General for the state respondents are present. Mr. Santiago has submitted that despite issuance of notice on 39/2024, the state respondents have not yet filed their affidavit in opposition. Mr. Ajungla and State Council representing Mr. Swensul and Additional Advocate General Nagaland has submitted that a last opportunity be granted. Last opportunity for 3 weeks
Lordship.
is be granted to file the affidavit in opposition on behalf of the state respondents. First of the prayer is allowed. Prayer for the last opportunity is allowed to raise their case after 3 weeks.
Lordship, item number 6, similar prayer. Behalf of Indigenous, additional agent. Lordship, we have kindly grant 3 weeks of that.
Six.
File affidavit.
Item number 6.
Lordship.
Who is for the petitioner? Mr. J. Shekil, Councilor for the petitioners is present. How much time?
3 weeks, Lordship.
Ajungla and State Council. Representing Mr. Im Chong. Learned Additional Advocate General Nagaland has paid for and is granted 3 weeks
Lordship.
time to file affidavit in opposition on behalf of the state respondents. First up, raise the case after 3 weeks on a day to please by the office.
Lordship.
Mr. Lordship, I beg to mention hearing item number 7. On behalf of L. Iralo. Yes, difficulty today. Only is to after 2 weeks.
Okay, Miss
National.
Learned Council has submitted that Mr. L. Iraro, Senior Counsel, is leading her in this case. And has submitted that Mr. Iralo has personal inconvenience today to appear in the court today. She has just paid for listing of the case after 2 weeks.
Lordship, there's an injury.
Okay. Who is the State Council, Miss?
Bijalo.
B. Chara.
Chalo.
Then a State Council who is in attendance, has not objected to side prayer. The praise allowed list the case after 2 weeks on a date to fixed by the office. The interim or if any shall continue till the next date of listing.
Lordship, I also like to beg to mention item number 11.
11. Yes.
Lordship, if I will be granted 3 weeks time to file my affidavit.
Miss Gibbs
Yes.
R. Machula Gibbs, Learned Council, the petition is present. Miss State Council has paid for and is granted. How much time?
3 weeks, Lordship.
3 weeks time to file an affidavit of opposition on behalf of the state response. This is the case after 3 weeks. Get to fixed by the office.
I will pledge.
Mr. Lordship, I beg to mention item number 8.
8. Okay.
Lordship, here I'm here to receive instructions, Lordship.
Uh,
So if 3 weeks time you granted to me, Lordship.
okay, Miss S.
S. Chang.
Shah. Who is for the petitioner? They have informed. Miss
Lordship.
R. Mary Learned Council for the petitioner is present. Miss Chang, Learned State Council has paid for and is granted. Has submitted that she has received an she has not yet received an essay instructions to file counter affidavit and has paid for further 3 weeks time to obtain an essay instructions and to file the counter affidavit on behalf of the state respondents. The praise allowed is the case of 3 weeks.
Much
The date
obliged.
is by the office. Item number 8.
Yes, Lordship.
Okay.
Lordship.
Lordship, I beg to mention item number 20 and 21.
20 and 21.
Lordship.
If this matter can be taken on some other time, Lordship.
Okay, R. Mere,
Lordship.
learned counsel for the petitioner. Has sought for listing of the case on another date. The prayer is made. You have informed Mr.
Lordship, I'm appearing for respondent number
Team
10.
Chong. Oh, sorry.
That'll be Sangam.
Sanctum, Atlantic Additional Advocate General. Okay. And you?
Lordship, I'm private respondent number 10 in item number 20. And respondent number 9 in item number 21, Lordship. I'll file
Okay.
my affidavit in opposition.
Sanctum.
Lordship.
Okay. Mr. So-and-so, Learned Additional Advocate General for the state respondents, and Ms. Apila Sanctum, Learned Counsel for the private respondents are present and have submitted that they have no objection to the same papers to release the cases after 2 weeks from the date to be fixed by the office. 2 weeks? 2 weeks?
2 weeks.
Okay. 2 weeks.
Lordship.
In October then.
Obliged, Lordship.
Please, Your Lordship, I may be allowed to mention item 9, Your Lordship. Here the state is yet to file counter.
9.
Item 9, Your Lordship. I may be
Okay.
kindly granted 3 weeks time.
Miss Amy, yeah?
In Oli.
Inoli. Oh, who is for the petitioner?
Oh, for the petitioner.
Mr. Fonseca Forte. Learned counsel for the petitioner is present, Miss so-and-so, Inahuli. Learned state counsel. How much time you need?
Your Lordship.
Okay. As prayed for and is granted 3 weeks time to file counter affidavit on behalf of the state respondents. Anybody present?
Respondent for
Mr.
Newton Jumong.
Jimomi and Jimomi. Fonseca Forte, petitioner, and Jimomi, learned counsel for the private respondents.
Lordship, there's an interim.
The interim order fast trader shall continue till the next date of this.
Your Lordship, I
Yes.
mention item number 23 and 24. For
20.
legal counsel, P. Suryan, representing respondent number 4.
Okay.
There's none. I'm for the petitioner.
Oh.
There's an urgency in the matter. So if that matter come up on Tuesday, Lordship, next Tuesday.
Tuesday. Yes. Tuesday,
23rd.
Mr. Suryan has any issue, problem?
No.
A prayer is made on behalf of Mr. P. Suryan, learned counsel for the respondent number 4. The paper adjournment is made on behalf of. By Mr.
Found the blue camera.
Okay. Mr. Fonseca Forte, learned counsel for the petitioners. And Miss Inaholi, learned state counsel for the state respondents are present. As sought for and as agreed to by the learned counsel for the parties, lays the cases on next Tuesday.
Last one.
May I please, Your Lordship?
Yes.
Lordship, hearing item number 18, behalf of additional AG, Dim Sum. Lordship, let this matter release next week.
Okay, on the prayer of Mr. So-and-so learned state counsel. Release the case in the next week. Miss,
Rebecca.
okay, Miss Rebecca, learned counsel for the petitioner is present.
I know.
Please, Your Lordship, may I be pleased to mention item number 16 on behalf of our additional AG, I'm Shankar, Your Lordship. If the matter can be posted next week. As,
Miss Livika,
yes, Your Lordship. on
Lordship.
behalf of-
Maybe, Lordship. Lordship, here, service upon private respondent is still awaited, Lordship. We have taken first step, but still awaited.
okay, we'll look into it. You are here? Okay, we'll look into it. Office notes, we'll look into it. Be here,
Your Lordship, Your Lordship.
be here.
Lordship.
If I have to look into the file, then I look into the file when the case is called.
Oh, Your Lordship. Your Lordship, I also like to mention item 1, Your Lordship. Here I have sent for vetting, Your Lordship, but there seems to be some correction, Your Lordship. So another 2 weeks will be granted for making the necessary correction and profiling, Your Lordship.
Okay. Miss Mere,
Yes, Lordship.
R. Mere, learned counsel for the petition is present. Miss Livika, learned state counsel has submitted that the affidavit in opposition for on behalf of the state respondents is sent for vetting, and the affidavit in opposition will be filed within 3 weeks' time.
Oh.
She has just prayed for listing of the case after 3 weeks. Her
Thank you.
prayer is allowed, list the case after 3 weeks in date 2 weeks by the office.
Thank you.
Mr. Learned Counsel for the private respondent. Okay, is present. We take a level petitioner.
Mr. Lordship. Lordship, I like to move in unlisted motions.
What is the urgency?
The urgency is there is an administrative order specifically issued by respondent number 3, where 7 days, the order was issued in 11 of this month. 7 days, within 7 days, election should be conducted. So
What election?
This is conducted with the constitution of VTP Village Development Board Management Committee, where the petitioner is appointed as VTP secretary by an order dated in 2023, but without any legal steps.
When the election is going to be held?
The election is fixed today. The
Fixed
extreme
today?
urgency is yes. The order
Okay.
was issued on 11, that is on Thursday.
Okay, if it comes in time, okay, we'll take up. Otherwise, you lose the opportunity.
Your Lordship, there's a slight communication problem, Your Lordship. I mentioned items 13, Your Lordship. It is not item 16. It's
Item,
communicated to me as item 16. It's item 13, Your Lordship.
you
Yes.
made the mention for what?
Item 13, Your Lordship, not 16.
Urgency is involved in this case.
What urgency?
And challenging the selection process which is going on presently.
Affidavit file.
Things are done, complete.
And who is trusted?
Here, Ma'am Shukri is appearing, Your Lordship, but because of the urgent matter in the principal seat, she has to go. So just seeking for 1 week to be posted next week. And it seems that he has also intimated to the petitioner council, Your Lordship.
Friday? Possible.
This
Next-
week, not possible, it seems, Your Lordship, but she will be in the principal seat, Your Lordship.
Monday. Okay, on the prayer of Miss Libica, Learned Counsel for State Council. List the case on Monday.
Your Lordship,
Mr. Tongpong Pongener.
Your Lordship, Tuesday.
Tuesday, I have fixed many matters. Monday. Pongener, Learned Counsel for the petitioners is present.
Much obliged.
Please, Your Lordship, I'd like to mention item number 22. I pray that 2 weeks time may be granted as my senior is unable to attend this matter today due to some personal difficulties.
You are for the petitioner,
I'm for the petitioner.
Miss
Toshi Jamir.
T. Jamir, Learned Counsel. For the petition has submitted that she is being led by Mr. C. T. Jamir, Learned Senior Advocate. In this case, she is in this, and has paid for listing of the case on another date due to personal inconvenience on the part of Mr. Jamir, Learned Senior Counsel. The praise made with the consent of Mr. N. Angami, Learned State Council. Who is in attendance. Yes, what is the matter about?
It's challenging the termination order.
When
Your Lordship.
do you want?
After 2 weeks.
After 2 weeks, okay. As sought for and as agreed to by the Learned Counsel for the parties, list the case after 2 weeks and date 2 weeks by the office.
Lordship.
May I please, Your Lordship?
Yes,
Lordship, kindly allow me to mention item number 3, Lordship.
yes.
Lordship, here I'm yet to file my affidavit in that.
How much time you need?
Lordship, if this matter may be fixed on 6th October as hearing, I will file it in a week time.
Okay, if I 6th October, fixed it.
Maybe after Puja break.
Okay, okay. In the second week of October,
Lordship,
okay, Mr.
James Newman.
Learned Counsel for the petition has sought listing of the case in the second week of October 2025. He has submitted that the affidavit reply on behalf of the petition will be filed within that time. First of Miss A. Aimee, Learned State Council is in attendance.
Lordship, similar prayer for item number 4.
4.
Yes, Lord.
Okay. JNU Mai, huh? Same.
Lordship.
Who is the State Council? Im Chong. You are senior government advocate.
Yes, why, Lordship?
YM, I'm sorry, YM. And Mr. Longkumar,
Lordship, I'm for the private respondent number 6.
6. Mr.
Jin Young Hong.
Present. Item number 4. 4.
Fourth.
Okay.
Lordship.
After 2 weeks. After 2 weeks. The interim order. Past idea shall continue till the next day of this thing.
Okay.
From the supplementary cost list for motion, item number 26.
Yes, ma'am.
Your Lordship, here the petitioner's a work charge officer appointed since 1994, and he has completed 30 years as in this year, August 2025, Your Lordship. So the petitioner is seeking for regularization of service as per the standing OM 2015 on, Your Lordship.
Have you annexed that?
Yes, Your Lordship, I have annexed OM. It's in my page
Page
13 annexed to 4, Your Lordship.
page 13.
Annexed to-
17 March.
Yes, Your Lordship, 17 March 2015.
Who is the state council? Chang. Heard Miss R. Achula keeps Land Council Board of Petitioner. And Miss S. Chang, Land State Council. You're junior government advocate?
Yes, Lordship.
Land junior government advocate Assam, Nagaland for
Respondent 1 to 4, Lordship.
all the respondents.
Yes, Lordship.
Full stop. The case of the petitioner is that the petitioner came to be engaged as work child's fitter helper on and from 1994 in the establishment of the executive engineer, it is public health engineering,
Yes, Lordship.
public health engineering, PhD department, Tuensang division. Full stop. The petitioner has claimed that he has rendered 30 years of continuous service,
Yes, as on August 2025.
as on August 2024. Then
This year, just last month, he has completed 30 years.
you said 1/8/1994. 30 years will be.
Yes, appointed on 1/8/1994, completed on August
The
2000.
petitioner has claimed that he has completed 30 years of continuous service as a work charge employee in August 2025. And as such, he is eligible to be regularized in terms of the policy of the government of Nagaland. Scheme is in terms of the scheme for regularization and absorption framed by the government of Nagaland and notified by the office memorandum dated 17/3/2025. Post of as the respondent authorities have not yet taken any discernible steps for regularization of service of the petitioner. Petitioner is before this court. Issue notice returnable 4 weeks as Chang has appeared accepted for all. No formal notice, extra copies, we need to open this. Raise the case after 4 weeks.
For motion, item number 27.
Your Lordship, here the petitioner is praying for, maybe this Lordship.
Yes.
The petitioner is praying for release of pending salary. The petitioner here was appointed pursuant to the Honorable Board order dated 21/8/2018. Your Lordship is appointed on compassionate ground, but since the initial date of his appointment until November 2024.
When you got the appointment order?
Appointment order is
24th May.
yes, Your Lordship.
Okay. Heard Miss R. Achula keeps Land Council for the petitioner and Miss
Pichano.
P.
Pichano.
Pichano. United State Council. For all the respondents?
Yes, Lordship.
1, 2, 3, 4, 5. All the respondents. Full stop. The petitioner has stated that he came to be appointed by an office order dated 24/5/2023 as Pharaoh
Printer.
printer on compassionate ground pursuant to a direction made in a judgment made in an judgment and order dated 21/8/2018. Full stop. Pursuant to the office order, comma. The petitioner joined as Pharaoh printer in the establishment of the executive engineer PWD within bracket RNB, Bhakti Division, Bhakti, page 15. Under NPWD department. In the pay scale mentioned therein, full stop. But the respondent authorities have not disbursed the salary of the petitioner for a period from May 2023 till November 2024.
Yes, Lordship.
Full stop. The petition is approached this court by an instant petition seeking inter-alia direction to the respondent authorities to disburse his salary for the aforestated period. Issue notice 4 weeks as friends of appeared accepted. Notice on behalf of all the respondents, issuance of formal notice to the said respondents dispense with requisite number of extra copies of the petition within 2 working days from today.
For motion, item number 28.
Yes.
Your Lordship, the petitioner is the son of the deceased employee who is seeking for compassionate appointment. The father died in harness.
When?
On 16th of July 2025, Your Lordship, 16/7/2025. So the petitioner is solely covered by the office memorandum, compassionate office memorandum dated 17/9/2015. And so Your Lordship, if the court is inclined to dispose of the case at this motion stage, Your Lordship, then I have no objection and leave the matter to Your Lordship's decision.
I don't have any objection for disposing the representation.
Is there any representation? No representation.
Representation,
You have directly come to the court.
Your Lordship, representation.
Where is it?
Your Lordship, the representation has not been made.
Huh?
Yes, Lordship, representation has not been made, Your Lordship.
Or page 13? Page 13? You don't know your case.
Oh, yes, Your Lordship.
You don't know your case. You have not read. You have not read your case.
My apologies, Your Lordship. Next 5, page 13, Your Lordship.
Heard Miss R. Achula keeps learning counsel for a petition and Mr.
Ajungli Lordship.
Ajungla learned.
Ajungli.
Ajung
Li.
AJGLI.
UNGLI.
Ajungli.
Yes, when it
Okay.
comes to La.
Yes, lady.
Yes, Lordship.
And I means the opposite.
Yes.
Okay. Learned junior government advocate.
Lordship.
Okay. Nagaland for all the respondents. Full stop. The case projected by the petition in brief is that petitioner's father, late Long Riemba, was a regular employee under the Power Department,
Executive Engineer Electrical Division Mokokchung.
under the Power Department.
Yes, under Power Department.
Comma, Government of Nagaland. Full stop. The petitioner's father died in harness on 6/7/2025, leaving his wife and a son within bracket. The petitioner and a daughter. Full stop. At the time of his death, late Long Grimba was serving in the establishment of the Executive Engineer Electrical Division, Mokoksang, Nagaland. Correct?
Yes, Your Lordship.
Yeah, full stop. The petitioner has projected that his father was the only breadwinner in the family. Full stop. Para. The petitioner has submitted that the state government has a policy for appointment on compassionate ground and scheme for appointment on compassionate ground has been notified. By an office memorandum dated 17/9/2015 and an addendum dated 9/4/2019. Full stop. As per the scheme, the petition, a son is eligible to seek appointment on compassionate ground. Full stop. Para. A petitioner seeking his appointment on compassionate ground had submitted a representation, an application before the respondent number
Respondent number 4.
4 on 8/8/2025. And the office of the respondent number 5 had duly acknowledged the receipt of the said application under its signature and seal. Full stop. As no discernible steps have been taken by the respondent authorities in the Power Department, Government of Nagaland, regarding the petitioner's application for appointment on compassionate ground. The petition is before this court by the instant petition seeking inter direction to the respondent authorities for consideration of his application. Mr. Spencer Leonard Ajungli, Leonard State Council, has submitted that as the petitioner stated that he had already submitted an application seeking his appointment on compassionate ground as per the scheme stroke policy of the state government, and the same has not yet been given due consideration, this state petition at this stage can be disposed of with a direction to the respondent authorities in the Power Department, more particularly, the respondent number 3 and the respondent number 4 to consider such representation within a stipulated period of time.
Lordship.
Post. Ms. Gibbs Learned Counsel appearing for the petitioner has submitted that she has no objection if the writ petition is disposed of with a direction to consider the representation of the application of the application dated 8/8/2025 of the petitioner. So in view of the broad consensus arrived at by the learned counsel for the parties in the apostated manner, and considering the facts that the petitioner has already submitted an application seeking his appointment on compassionate ground in terms of the scheme stroke policy of the state government, I would have considered view that instead of keeping this writ petition pending, the writ petition can be disposed of with a direction to the respondent authorities in the power department, more particularly the respondent number 3 and the respondent number 4, to take the representation stated to have been submitted by the petitioner on 8/8/2025, on board, and thereafter consider the application in terms of the scheme stroke policy of the state government for compassion, for appointment on compassionate ground, as notified by the office memorandum dated 17/3/2025 or 15 and addendum dated 9/4/2019. First of, it is accordingly ordered. First of, it is observed that the respondent authorities shall consider the application of the petition on its merits, on its own merits and in accordance with law, and thereafter shall pass a speaking order within a period of 6 weeks
Lordship.
from the date of submission of a certified copy of this order by the petitioner at the office of the respondent number 4.
Deeply obliged.
With the observation made above, with the observation made and directions given above, the writ petition is disposed of.
Obliged.
For admission, item number 5.
The petitioner
Lordship,
has filed this for what?
Yes.
I'm appealing Professor Lordship. I found out the last week Lordship. I've instructed the APM to respondent number 5 Lordship.
Well, you are appearing for the first time.
Yeah, for the first time.
Yes, for the first time.
My lord, lordship will appreciate one thing. This was filed in 2024. And now this is the 9th time they are asking adjournment. 9 times.
Lordship, I'm appealing.
And my lord, you see, he may be appealing, but because of the client, the respondent profile, they are not coming forward. It's not his mistake. The client is not engaging any counsel. Government is asking adjournment for 9 times. And my lord,
By your writ petition, if writ petition is allowed, then respondent number 5 is going to be affected.
yes.
Then he has a
Correct.
opportunity issue.
I agree that.
Ah.
The only problem is why that he doesn't engage counsel from people. 1 year now. 1
Oh, that I don't know.
That's why I'm trying to advise the court.
He was looking for the right counsel, and now he has ultimately found Mr. Mojui. He may be looking for the right counsel to defend his cause. Yes, madam, you are filing, you have filed your affidavit.
Lordship, where
Why you are-
assisting additional AG membership career, Your Lordship, we may not need to file also, Your Lordship.
You did not file affidavit.
And the-
We'll record that.
Then we-
No, Your
then-
Lordship, Your Lordship, let it come up next, after the meantime, Your Lordship, discussion can be not.
That then case will progress. If you say that you need not have to file affidavit.
Your Lordship, so 3 weeks will be granted since there are also.
My lord, like I said in my response, this is a year now, 2024.
What is the matter about? What is the matter about?
Yes,
Shortly,
correct,
promotion,
correct.
interstate security, what is the matter about?
Promotion.
Promotion.
Petitioner has filed for warrant to oust her from.
Response number 5.
Yes.
Okay, go on.
He has a case of a service rule where they don't have, their wing doesn't have a deputy director post. They are getting promotion through our post.
I have announced the judgment.
Lordship, that is with regard to the interpretation of the.
Mr. Moju, how much time you need?
3 weeks, Lordship.
3 weeks.
Yes, I will file my objection.
And Miss,
I will intimate the same to you.
okay, we'll put a fixed date.
I'm tired of objecting all the time, so I leave it with the lordship. Because this is ninth time,
Heard Mr. A. Joe, learned counsel for the petitioner, and
10th time today.
Ms. Livika, learned state counsel representing Ms. Sukri, learned additional advocate general for the Nagaland, for the respondent number 1 to 4, full stop. Also heard Mr. N. Mojui, learned counsel for the learned counsel who has also heard, Mr. N. Mojui, learned counsel has, who is in attendance, has submitted that. He has entered appearance on behalf of the respondent number 5.
Yes, Lordship.
Full stop. Mr. Joe has pointed out that since
It will be 10th time today. Asking adjournment.
will not count.
I count from the diary.
We call it 10th item.
When notice was issued,
Notice was issued on 3/12/2024.
since the state respondents were put to notice on 3/12/2024. But till date, the state respondents have not filed their counter affidavit. Full stop. He has thus submitted that since the subject matter of the petition is promotion
Correct, ma'am.
of the petitioner
Yes,
and ouster of the respondent number 5,
yes. Because
the respondents should file their affidavit at the earliest. Full stop. Ms. Livika has prayed for a last opportunity. Has prayed for 3 weeks' time as a last opportunity to file the counter affidavit on behalf of the state respondents. Full stop. Mr. Mojuish has also sought for 3 weeks' time to file the counter affidavit on behalf of the respondent number 5. Full stop. The prayers made by Ms. Livika and Mr. Mojuish are allowed to list the case on after 3 weeks. 7th of October, 2025, full stop. The state respondents shall ensure that the counter affidavit is filed on or before 7/10/2025.
Mother plan. I know there is interim also.
Interim order shall continue till the next day. Then you are enjoying interim order, why you are?
There is difficulties, there is something moving inside.
Shall continue till the next day.
He can foresee the.
No, moving inside is not material. Moving out, what is moving outside is material.
Lordship, see, there are a lot of manipulation.
For admission, item number 7.
This is Lordship. Lordship, I have received instruction to appear on behalf of the respondent 1. However, Lordship, there is an IA for condition of delay also, but upon going through the records and after proper verification, Lordship, I have found that this case is become totally infructuous. Lordship, kindly allow me to explain the facts. Lordship, the petitioner,
Some payment.
yes, the appellant has filed.
Civil court directed some payment.
No, Lordship.
Yes, your
Yes, the case is about fraud, the issue relates to fraudulent travel of the respondent's GBF,
Okay.
lordship.
It has been sanctioned.
Why not?
The amount has been sanctioned,
Already paid,
paid.
already paid.
And we did not know till this morning, your lordship. So in fact, I'm quite relieved, my lord.
Actually, the issue is
For the
this.
accountant general.
I'll give you in the gist, short facts, logic. The petitioner is a now retired from the Department of School Education. While serving as district education officer at Dimapur, it was detected that her GPF amounting to rupees 3,90,340 rupees was fraudulently dropped. Accordingly, complaint was lodged, then verification was done, then the vigilance inquiry was conducted, and then the vigilance inquiry found that it was fraudulently dropped. But then it was not reimbursed, so she filed a civil suit 15 of 2014. Then on 25/2019, the learned court below passed an order directing the accountant general to pay that amount on the ground. That, however, lordship, and against that, this appeal is filed. But due to inadvertence, lordship, the school education departments had already paid the for the amount to me already by this 14 February 2019 letter and 15 February 2019 letter, but due to inadvertence, the council, neither government council nor the council representing the plaintiff in the law corporately notice of the never court below that is paid. And now there's a big tug of war between the two departments who will pay. And the department, the school education department also were objecting without verifying the reports that AG should pay, whereas he had already paid me also.
Okay, AG has come, AG office has come in appeal.
Yes, before direction was for AG to pay.
And there was delay.
Yes, there is delay.
And this application is for condonation of delay.
There is a delay. Yes.
And that is a period is huge.
Yes.
Yes.
But then
Take your call.
In fact,
In view of this development, take your call.
yes, you can.
Your application might suffer dismissal also.
Yes, your lordship. Since the
Might suffer dismissal.
Yes.
my lord, amount is already paid and
Take your call.
respondent is no more.
You want withdrawal or dismissal?
We'll withdraw it, your lordship.
Yes.
My lord.
Yes.
That is, otherwise you'll
Yes,
get dismissal.
My lord, your lordship.
Yes.
Lordship, yes.
Heard Mr. J. Sheki,
Yes. My lord.
learned counsel for the appellant. Mr. Takamasa, you are appearing for opposite party number 1.
Yes, Lord.
Asono,
Yes, Lord.
Mr. Takamasa, learned senior counsel, estate by Mr. Aaron Long. Senti Long. Learned counsel for the opposite party, that's respond number 1, and Mr. N. Angami, learned senior government advocate. Nagaland, for the opposite party, that's respondent number 2, 3, and 4. Full stop. The instant interlocutory application under Section 5 of the Limitation Act 1963 has been preferred by the appellant seeking condonation of delay of
My lord, 1,447 days.
in preferring the accompanying first appeal number 1/2025 against a judgment and decree, judgment dated
25/2019, my lord.
and decree dated 22/05/2019 passed by the Court of Learned Principal District and Session Judge Dimapur in civil suit number 15/2014 post up by the judgment and decree aforementioned judgment and decree, the learned civil court, learned trial court had directed the office of the applicant, that is the principal accountant general Nagaland to pay a sum of rupees 3,94,000, 90,340 with interest at 9% per annum within a period of 2 months. First of para, Mr. Akamasan and Senior Counsel appearing for the opposite party number one, opposite party, that's respond number one. That is the degree holder.
Yes.
Has placed a communication bearing number so and so, dated 13th February 2019.
14, my lord.
14th.
14 and 15.
Two packet for
Okay, two. Huh? Of the Department of School Education, Nagaland. To submit that the opposite party, that's respond number one, that is the degree holder, has already been sanctioned an amount of rupees 3,90,340 by the School Education Department, Government of Nagaland.
and receive all the budget.
Post of Mr. Takamasa has further submitted that the PT so and so, the degree holder already received the said amount. Post of. And as such, the opposite party, that's respond number one. As the opposite party, this respond number one had already received the amount in February 2019.
Yes.
She had no further grievance in the matter. Post of. Mr. Sekil and a counsel preparing for the appellant has submitted that in view of such, he was not aware
My lord.
of such developments.
My lord.
And in view of such developments, the appellant does not want to press this application.
Your lordship.
Post of. In view of the above submissions made by Mr. Sekil and counsel for the petition appellant, the instant application is dismissed as not pressed. Post of. In the FA. In view of the order passed today in the accompanying interlocutory application IA Civil number 7/2025, the instant appeal stands disposed of accordingly.
Obliged, your lordship. There is another idea.
Huh?
There is another idea, my lord. That was
Okay. Okay, in view of the order passed today in the accompanying interlocutory application number so and so, and accompanying first table, FA number so and so, the instant interlocutory application stands accordingly disposed of.
My lord. Lordship.
এইটো প্ৰথম অৰ্ডাৰটো কিন্তু সেকশন 5 লিমিটেশন এক্টৰ আন্ডাৰত হ'ব।
For admission, item number 14.
Well, this paper should be listed in the still stage.
Huh?
This is yet to be issued.
Oh, notice is yet to be issued.
This should be in the stage. However,
Oh, any state respondents counter? Any affidavit is filed? Affidavit is filed. This is regularization.
regularization.
Very as to the petition general to get provision after the petition was released from service. Why this query was made?
Lordship.
Why the query was made on the previous date?
That was the very big by this court.
Yes.
However, Lordship, my humble submission is, in terms of hospital judgments, around the ethics court and other.
Have you challenged that? Your release?
No, Lordship. I was released after serving for.
18, 6, 30, 11.
I was superannuated, Lordship.
You got superannuated by that order.
Yes.
Where is that?
Page 26, Lordship. After release lordship, my case was put up before the government. And the government by giving lordship, we carried communication. This the letter by which my prayer was rejected.
And what is the requirement? As per the office memorandum 17.3,
As per the petitioner case.
how much service?
After completion of 30 years.
So you are 24.
Yes.
And as per 2004, it was, I think, by seniority
Lordship.
on both counts.
That is the reason given in this letter, Lordship. Because my case doesn't come under OM up to 2015.
Why?
Because I'm yet to attend 30 years of service.
Yes, only 30 years of service, you have a
I'm not
right.
blaming- I'm not blaming regularization of my service.
Okay.
under this. Because my case doesn't cover under 2015 OM, nor in 2004 OM, because I'm already released.
Yes.
Because this OM of 2004 pertains to a service regularization.
Then posthumous regularization, is it possible?
Under 2000.
That I think there is a Supreme Court judgment also.
If that is the case, the respondent also have considered my case under the 2004 OM.
There is no post-retirement regularization is possible.
Lordship.
Possible.
Yes.
Show me any instances.
There are judgments rendered by the Honorable Supreme Court as well as by this Honorable Court, Lordship.
Show me
And
anything.
so that after some judgment in my petition and.
Yes, Mr. Angami.
Oh, was M. Longpura. Yes.
M. Longpuma, right.
So.
What do you say? Notice has not yet been issued.
Not yet issued. But this may be issued without it.
Okay. But Mr. Wati Jamir, learned counsel for a petition and N or M?
M.
Ram Kumar, learned state council. For all the respondents.
Yes.
Those two. The petitioner was initially appointed as a war charge Mali with scale pay
Lordship.
by an order dated 22/04/1998 in the establishment of the executive engineer. Part control within bracket works division, Dimapur. Postal. Subsequently, she was reappointed as Khalasi in skill pay by another order dated 25/8/2025. Postal. 2005. The petitioner rendered continuous service for a period of 24 years till she was released from service by an order dated 15/12/2022 on the ground that the petitioner reached the age of superannuation of 60 years on 1/12/2022. The petition was released from service with effect from 30/11/2022. The petitioner has approached this court by the instant writ petition seeking regularization of her services of 24 years for pensionary benefits. Mr. Jamir, learned counsel for the petition, has submitted that the state respondents appear to have rejected the case of the petition on the ground that the petitioner would not come within the purview of the scheme of regularization framed by the government and notified by the office memorandum dated 17/3/2015. It পিছত দিব, আগত দিব। Office memorandum dated 22/9/2004 and office memorandum dated 17/3/2015. Closed. Okay. Issue notice returnable 4 weeks as Longkumar has appeared for all the respondents. Formal notice dispensed with extra copies 2 working days.
For orders, item number 15.
Yes,
Colored no file. Yes, Mr. R4 has appeared.
I believe, Lordship. I believe so, Lordship. The file-
But Okaran, who is the Okaranama? Okay.
Because this name.
Abid Ali J. Kunlu, J. Kunlu.
Yes.
Let their name be reflected. Is
Yes,
the case
Lordship.
after 1 week?
After 2 weeks, Lordship.
After 3 weeks?
3 weeks after study.
You don't file any affidavit. State has no
No,
file.
Lordship.
Poseko Hotel, Mr. Poseko Hotel, Learned Counsel for the petitioner, and Mr. M. Longkumar, State Counsel for the respondent number 1 to 3. Post of office note dated 15/9/2025 has reported that the respondent number 4 has entered appearance through Learned Counsel by filing, who has filed, post of. However, the names of the Learned Counsel for the respondent number 4 are not reflected in the call list. Post of. Office the registry to reflect the names of the Learned Counsel appearing for the respondent number 4 in the cause list. Post of. Mr. Longkumar, State Counsel has prayed for and is granted 3 weeks time to obtain the necessary instructions and to file a counter affidavit on behalf of the state respondents. Release the case after 3 weeks.
For orders, item number 16.
Yes, morning, somebody said.
Lordship.
Yes, now morning, somebody, okay, service report. Respondent number 7.
Yes, Lordship.
You want to take first steps?
Lordship, in fact, the service acknowledgement and seven is being returned back and delivered, Lordship.
Oh,
So,
to take first steps at the correct address.
Lordship.
What is the address of the respondent number 7? What is the matter about? Land ownership,
Yes, Lordship.
appointment.
Yes, Lordship.
She is the,
Landowner, Lordship. Petitioner is the landowner.
and respondent number 7, who is she? She has been appointed.
No, Lordship.
She is a contender.
According, they have, yes, Lordship.
Respondent number 7 is an aspirant for
Yes,
the
Lord.
same post.
Yes, Lordship.
Then she should be served. She should be served.
Yes, Lordship.
In her absence, your claim may not be considered.
Yes, Lordship.
So take first steps.
Lordship, my.
If it has returned
Yes, Lordship.
without service.
Substitute steps. Lordship.
You are saying
Yes, Lordship.
it has returned without service.
Undelivered, Lordship.
Undelivered means without service.
Yes, Lordship.
So you take first steps.
Yes, Lordship. Fresh steps through publication in newspaper, Lordship.
Why? What is the reason for non-delivery? Is there no post office, Mr. Longkumar,
Lordship,
in state of Nagaland?
we do have, we have,
You have post office,
yes.
postal service or not?
Yes, Your Lordship.
Then why village council is writing about non-delivery? You have sent by post,
Yes, Lordship.
huh?
I have sent through post, Lordship, and then the parcel was sent to the village, that is Chapman village, Lordship.
Right, who delivers the postal article?
They have represented.
Whether it is Gaubura delivers the postal article or peon from the postal department delivers the
Lordship, there's a
registered article, please tell me.
postman representing the village, so he delivered.
He's an employee of the postal department or he's an employee of the village council?
Lordship, employee of the post office.
Post office.
Yes.
Then how this village council is authorized regarding delivery or non-delivery? This has no value. No value. If it is a registered post, what are the steps? Registered post with AD.
Lordship.
It is a responsibility of the postal department to say the item has been delivered or has not been delivered. If it is not delivered, they will assign the region with endorsement in the postal article. The registry of the court has not yet received the registered article back. So office note says, service report in respect of respondent number 7 is still awaited. So we cannot take cognizance of what the village council says.
Lordship,
They are not authorized to say so. That article is lying in the post office. This respondent number 7 has not yet collected the item. So take it back.
Lordship,
Am I clear?
Yes, Lordship.
So registry will wait for the non-delivery of the postal article from the postal department only.
Lordship.
It is a registered article. Take fresh steps
Lordship.
at the correct and proper address of the respondent, or otherwise we will await. Let us await for 1 more week or 2 weeks as regards
Lordship.
service of notice, because it has not yet reached, sir, the registry.
Lordship, in that case, allow me to take first step, Lordship, by today itself, Lordship. To register it.
Mr.
Longgang yang punya.
Council for the petitioner and Mr. M. Longkumar and State Council for the respondent number 1 to 6 are present. Most of Mr. Soensu and Council for the petition has submitted that the petition be allowed to take first steps for service of notice of the respondent number 7. Post of. In view of the office note dated 10/9/2025, post of as per office note dated 10/9/2025. Service report in respect of the respondent number 7 is still awaited. Post of await for the service report in respect of respondent number 7. Post of as prayed for, the petitioner is also allowed to take first steps for service of notice of the respondent number 7 at her or his his
Yes, Lordship.
correct and proper address by registered post with AD within 3 working days from today. List the case up for 4 weeks.
Lordship, there is an interim.
Interim.
Yes.
The interim of the past idea shall continue to the next.
From the supplementary cost list for unlisted motion, item number 29.
Yes, State Council. We have received a copy.
Yes, Honorable.
Okay. Let me have a look at your synopsis first, then we'll.
No,
How many petitioners?
three petitioners.
Three petitioners, okay. Your serial number appears where?
My serial number appears in the appointment one.
Ajum. This is
Yes.
P1,
Petition number one.
P1. Then who is petition number 2?
Two.
P2.
is,
Serial number 2.
Three.
Huh?
Three.
Benjamin. Okay.
Benjamin.
He is 3.
Three. And petition number three is name appears serial number seven.
Najarno Ajum,
Lodge.
7.
Lodge.
Okay. Five and 6. 5 and 6. Present petitioners. Where is the judgment?
Annexed to page number 7.
Who were respondents there?
The respondents are petition number 2 and 3 are respondent number 5 and 6 in the report.
1 minute. 1 minute.
And the petitioner.
1 minute. 1 minute. 1 minute. 1 minute. This 26th August 2025,
Lordship.
page 27.
Lordship.
And then another letter,
Yes.
page 11, page
45. Yes, sir.
45.
This is in continuation to the letter or rather the directly issued, which is at the next year's please.
Okay, this is one. And how petition number 1 is aggrieved?
Lordship, he's the incumbent VTB secretary.
Okay, that is one.
Yes.
He has not been removed. He is in position.
Lordship,
He is in position,
Lord,
right?
correct,
Now petition number 2 and petition number 3.
Lordship.
How they are aggrieved by this page 44 and page 45.
Lordship, as far as the petition number 1 is concerned, Lordship.
We'll come back on petition number 1 later on.
Lordship.
He is still holding the position. His position has not been disturbed,
Yes,
right? Now petition number 2 and petition number 3.
Lordship.
How they are aggrieved by page 44 and page 45.
Lordship, by this order, they were already removed by an order that is on 13th of August, when the responding authority, that is the Deputy Commissioner, respondent number 2, has conducted the selection or election process.
Now,
Lordship.
petition number 2 and 3. I have seen your prayer,
Yes,
right? Now that
My-
13th August 2025, this order
man,
is not under challenge. Page 43.
Lordship.
Who has the power to appoint or constitute the village development board?
Deputy Commissioner, Lordship.
Deputy Commissioner.
Lord.
So power to appoint includes power to cancel.
Yes.
I think section 6 General Clauses Act.
Right.
If it is not provided in your rules,
Lord.
otherwise General Clauses Act, power to appoint includes power to cancel,
Right.
right? Now single judge, the Korean bench has said, right?
Lord.
Para 14, 15 is somewhat, you have to understand.
Yes.
Initially it says private respondent number 5 and 6. Therefore, a selection, election of private respondent number 5 and 6 members as members of so and so is set aside,
Yes.
right?
Yes, sir.
But paragraph 16, it is again kept in abeyance.
Right.
Whatever, we have to give a meaningful interpretation.
Yes.
It was kept in abeyance. Deputy Commissioner was directed to make an inquiry, and whoever gets more support, automatically, if you have got more support, you will remain as members.
Right.
But till then, it was kept in abeyance by the order at page 43. Now you have one petition number 3. Lost by 0 to 24.
Yes.
0 vote in her favor and 24 votes against her opponent. And petition number 2, how many votes? 0. Maybe one or two, right?
Right.
And his opponent got 44 votes.
Right.
So naturally, your appointment as members have been cancelled.
No.
See the last word,
Yes.
cancelled.
Yes.
Your member,
No.
your position as members, petition number 2 and 3,
No.
that is gone.
Yes. As per this order.
As per this order. If that is gone, then how you are concerned with member secretary selection? Because you have to have locus standi. Where is the locus standi? You have to have locus.
No.
Petition number 2 and 3, they are no longer member. You are not challenged. These petitioners are not challenging their cancellation of appointment. If they are no longer member, and that has gone in 13th August,
No.
and you have decided not to challenge, meaning thereby you have accepted your position. You have lost by 0 to 24, 0 to 44. Am I correct?
No.
Then how you were agreed by the selection of member secretary? Who will be the member secretary? Any member from the board?
No. From the board.
So where is the urgency? The first question is locus.
As far as the 2 and 3, petition 2 and 3 is concerned.
Yes. And petition number 1, he is holding the position of chairman. His position has not been disturbed in any manner whatsoever. How he can join 2 non-members to institute this petition? How many members in the board?
Yes, 7.
7. He decided to join 2 non-members whose appointments have already been cancelled and no challenge to those cancellation. So there is a locus. And he's joining 2 non-members is giving a bad signal.
As well as, yes.
Otherwise, if you don't challenge your appointment order, your locus is in doubt. Not to speak of any interim order, but the very maintainability of the writ petition is in doubt. You have accepted your position as non-members. Your appointments have been cancelled on 13th August. And power of the deputy commissioner, I have asked, I have not gone through the rules. Power to appoint includes power to cancel. If the deputy commissioner has made it, either you have a provision for appeal or for writ petition. That you have not done. So at this stage, we can only issue notice, keeping the point of maintainability open, as well as locus. You have anything to say, please say.
Lordship, as far as my prayer portion is concerned, yes, that's basically the issue is that the order dated 13th August 2025.
Your main attack should have been to the order dated 13/8/2025. If it is not there, you are not eligible for member secretary. And if you're not eligible, then how can you challenge the process?
Lordship, we appreciate that as we have already gone through the record, the petitioners were all appointed by the same order, that is on 8 November 2023. And the respondent number 5 and 6, who are the petitioners?
They made a challenge. Your appointment
No.
is in doubt.
Yes.
And there is a judgment and order of this court that the coordinate bench has put that out. Let there be a new process for election. How many votes you two can gather or your opponents can gather. And you lost by 0 to 24, 0 to 44. Meaning thereby very bad defeat.
That is, if I may, Lordship.
Please.
Nothing to accompany that. Noble court, Lordship. Lordship, that is in respect of the 3 and 4 petition number 2 and
2 and 3.
As far as the judgment of why this honorable court is concerned, it is limited to the the reselection or election of respondent number 5 and 16 is engaged with the petitioner. Now the final order dated 26 August 2025, it has contradicted that by giving actually a direction to reselection, whereby the judgment, my position was not frightened of.
Whose position?
My petitioner number 1 as a VTP secretary.
You are VDP secretary.
Lordship,
Where have you said?
Lordship,
Where is the original appointment?
base number 16, Lordship.
Page number 16.
Lordship. As an actual.
Ajung. Huh.
Serial number 1, Yamboto Izum,
Huh.
is the petition number 1.
Huh.
And in the judgment, Lordship, was by this number board in WBC 291.
Huh.
23, final order dated 31 to 25.
Yepong Tung Ajung.
Yamboto Izum.
Huh.
Yes.
Where is the model rules?
Lordship.
Model rules, VDP model rules.
Sure.
See the book, which one? So why you have joined this petitioner 2 and 3? Why petitioner 1 has joined petition number 2 and 3?
Lordship,
They have no locus. Absolutely no locus. They are out already by procedure of law. Model rules. Where is the model rules? Model rules available.
what is the after?
Huh? Page.
Page number 23, Lordship, that is the.
Page number
Yes.
23.
This is the model rules starting from the.
Where is the provision for member
Point number
secretary?
16 is from it's section number 4.
4.
It's section 24.
1 minute. Where is the village council? Where is the village development board? We are concerned with village development board?
Yes, sir.
Huh. As per village development board. It is like managing committee.
Yes, sir.
Over and above it is the village council.
Yes. For selection also the, it is empowered the village council to constitute the board.
How the member secretary is to be selected?
From among the, from within the management committee.
Which
who-
is
who
the rule?
enjoy the-
Which is the rule?
Mm, Lordship, 7. Lordship. The
Hmm?
member 7.
7.
This is section 25, section 7. The member of the management committee shall select one among them, the secretary, who shall be a person who is elected having a difficult that is
Hmm.
7.
Now you two, petition number 2 and 3 have been replaced by new members, new 2. Definitely there has to be a by the members. The composition has been changed.
Yes, I think that you.
Yes.
First,
It will be 4/3 or at least 4/3. There's new two members, they have the option of selecting the secretary. Either by raising their hands or by election or selection. Now your position is in jeopardy.
Yes.
Unless you get the confidence of the new members, your position is in petition number one's position is in jeopardy because there has been change in the composition. And it is a democratic body. And 7, member secretary has to enjoy the majority support to continue as. So you try to garner support of the members, not through the writ petition.
My lord, you're behind that time, I'm so sorry, apology for that. But just one point that I want to make. All along we have put, especially to be very precise, the petition number 1 is DLM in this position because of the fact that there is in High Court, this honorable court judgment, whereby the petitioner in that writ petition.
Earlier the petition number 1 was not a party.
Petitioner.
Let us see.
Yes, petitioner 1 and 2 in that writ petition.
So he is not concerned. Petition number 1 and 2, 1 was not concerned with the earlier round. Petition number 2 and petition number 3, they were petitioners. Right? And their position is gone. They are out.
Lordship, Mrs. Apology. In the earlier writ petition, the instant writ petition, petition number 1 and 2 are the private respondent in that writ petition.
But they are not the petitioner.
They are not the petition. Here, in the earlier petition number.
Yes, petition number 1 was never a party.
Was never a party.
In the earlier round.
Therefore, the honorable court judgment, give me my point.
That writ petition was with regard to the petition number 2 and petition number 3. And their opponents, two opponents. Then everybody gone for election. They won by majority. 44:0, 24:0. To petition number 2 and petition number 3, they are out already. Deputy Commissioner, who has the power to appoint, power to cancel. He has cancelled it and they have not challenged. So they have accepted their position. Now the petition number 1, to continue as the member secretary of the village development board, he has to have majority support. Now you have said there are 7 members. So he has to garner the support of at least 4 because new incumbents have joined. New incumbents has joined as board members. We don't think, and why petition number 1 has joined petition number 2 and 3? That is not giving a good signal.
My privilege, my lord.
We'll issue notice, sir. We'll not do anything. If you insist for interim order, we'll observe accordingly. We'll decide on the interim prayer.
Lordship, till the next reasonable day, Lord.
This I'll decline by expressly observing what I have said already.
Yes. Then in that case, my lord, I'm sorry on that. My lord, I was given only 3 days.
When is the election?
It was fixed today actually. Now the issue.
Petition number 1, good sense should prevail on him that he should garner support of at least 4 to continue as the member secretary.
For that, Lordship.
Then it is up to you.
If the Lordship can, at least till the next reasonable date is the proposed election may be postponed so that.
No, I am dismissing. I am declining the interim prayer. I am not finding anything. Some collusion and connivance between petition number 1 on one hand, petition number 2 and 3. I am not finding anything. And this election notice was in 26th August. It was a continuation. Second one is a continuation. That is not giving a new cause of action. We can only issue notice, nothing more. If you win the election, petition number 1 will survive, but petition number 2 and 3 without any challenge, they cannot continue. Their appointment has already been cancelled. Yes, Mr.
May I please lordship? My lord, my submission is, as you said, the petitioner has approached this court every major, my lord. Because as your lordship has said that petitioner number 1, as per the court order, is still holding the position.
Huh?
Yes.
He's holding a position and
Yes,
he'll
sir.
be contesting the election.
Yes,
huh?
ma'am.
He'll be contest. If he loses support of majority, he's out.
Yes.
This is a democratic body, sir. And Rule 7 says clearly, members of the managing committee shall select one among themselves as secretary. So they are selecting.
Lordship, I appreciate that. My grievance is, the Lordship should notice that I have no issue with that. But
So for interim prayer, you are insisting for interim prayer, you have moved the case unlisted. That is why I am saying, I have read the entire brief now. I have gone through the rules also.
My lord, one submission, my lord. Here the petitioner number 1 is not the aggrieved party. Because his.
He is a bit aggrieved because his position is in danger.
Yes, that is right.
He is aggrieved, not that, but why he has joined hands with petition number 2 and 3, that I don't know. Heard Mr. Y.W.R. Anguli Learned Council for the petition and Mr. T. Form,
Yes, my lord.
Learned State Council,
For respond number 1, 2, and 3.
1, 2 and 3, full stop. The petitioners, comma 3 number, have joined together to institute this rate petition to assail a notice to assail 2 communications, comma, dated 26/8/2025 and dated 10/11/9/2025, issued under the hand of the respondent number, so issued by the respondent number 3, whereby the chairman of the village council, comma, Wimkha village, YIMKHA, has been asked to take necessary steps for election of a new village development secretary from amongst the present Village Development Managing Committee, PDBMC members. Poster. Mr. Anguli Learned Council for the petition has submitted that the election of the VDP secretary is scheduled today. And as such, there is an urgency in the matter. Poster. From the materials brought on record, comma, it is noticed that the petition number 2 and the petition number 3 were earlier members of the village PDB,
yes,
Wemkha village, but their appointments as members have been cancelled by an order dated 13/8/2025, passed by the respondent number 3. Post of the respondent number 2, the petition number 2 and the petition number 3 have not challenged the said order of cancellation dated 13/8/2025. Full stop. The petition number when the composition of the village council was with the petition number 1, 2 and the petition number 3 as members. The petition number 1 was selected as the secretary of the VDP, and he has been continuing in such position till date, full stop, with the composition of the VDP MC, VDP MC, been changed with the ouster of the petition number 2 and the petition number 3 as members and inclusion of 2 new members, comma, an occasion has arisen for selection of the VDP MC secretary in terms of Rule 7 of the VDP Model Rules 1980 within bracket revised. Full stop. The matter would require consideration, issue notice returnable for weeks. As Mr. Tivapom has appeared and accepted notice. Mr. Tivapom has raised the question of maintainability of the writ petition on the ground that the petition number 2 and the petitioner number 3 are no longer members of the VDP MC Yumka village. And as such, they have no locus to challenge the process of election stroke selection of the VDP MC Yumka village scheduled today. First of, on the other hand, the continuation with the composition of the VDP MC having been changed with inclusion of 2 new members in place of the petition number 2 and the petition number 3, an occasion has arisen for selection stroke election of a new secretary in the VDP MC Umka village. First of, as it is a democratic body, the petition number 1 has to prove the continuation of the petition number 1 as the VDP MC secretary, Goenka village, is definitely subject to the process of the democratic process as contemplated in Rule 7 of the so-and-so rules revised. Was the matter would require consideration. 4 weeks, extra copies within 2 weeks. Steps upon responding number 5 and 6. Register post AD. The prayer for interim relief is kept open for consideration at the appropriate stage. Glimmer of hope.
What's all that?
Yeah, I'll just come back. Yes, Mr. Takama, say anything? I'll just come back after 5 minutes.
For hearing, item number 19.
Yes, you sought adjournment on the earlier date.
Your Lordship, the petitioner is here. Lordship, the petitioner is attending his nature also.
Okay,
Attending a nature.
okay, next, I think. Yes,
Yes, we will. In this matter, I'm praying for leave engagement with the gratuity.
gratuity.
Yes, the gratuity. The petitioner is the foster mother of the deceased.
Foster mother.
Yeah. She is the holder of succession certificate and the guardianship certificate.
Where is that? Where is that? Principal judge. Who is the petitioner? Telephone Leno. whereas has applied for guardianship certificate for the under-mentioned minor. 7 of the swing, so guardians and WhatsApp. Guardians and WhatsApp direct. Guardians and WhatsApp direct. Who is the diseased? Baoleno.
Yes,
And these come to page 41. These 5 children is of Baoleno.
yes,
And this foster mother is the second wife of Baoleno.
no, he is the stepmother of Bauleno.
Second wife?
Yes,
Second wife
no, he's not the wife, he is the mother.
or mother?
Yes,
Then there is a second wife.
yes, there's another second wife whom he has already divorced.
Huh?
Yeah, yes, no.
Where? Divorce?
Annexure. Annexure G43,
Hmm?
page 43.
Page 43. Tosovino Leno. Tosovino Leno.
Isocielo Leno.
Huh? Teso Sieno Leno.
Yes. No,
Huh?
She had issued a no objection.
This Tello Conio Leno. She is again girl.
In annexure page 42, the second wife, Tisovino Leno, has also issued this no objection.
Come to page 46. This Teso Sinio Leno.
Yes.
Right.
Yes.
She preferred the application for divorce.
Yes.
Is it possible to seek divorce after the death of her husband? I have not come across. Huh? It is a nullity. Yes, Mr. Takamasa. After the husband died, how can there is no opponent. She is the sole applicant. My husband died few years back. Now I seek divorce. Is it possible to pass a decree like that? Retrospective effect. When can it be a decree? You are raising very complicated questions. This is beyond my comprehension. Can it be a decree? How can the divorce has to be effected during the lifetime of her husband? Otherwise, she remains a widow.
She's a widow at the time of,
Her husband's death.
no, there's no husband.
No, let Bawal Leno, her husband, he died. He died when? 33, 2020. After that, she preferred the application, seeking divorce. And she was the first wife. Those are her children. Those 5 children, 6 children are this Teso CNU Leno's children. She says so.
Yes,
Huh?
yes. All the 5 children are from Tisosino. And with the second wife, Tisofino, she does not have any children with the.
Huh. So Teso CNU Leno was first wife.
Yes, Your Lordship.
And during subsistence of the marriage with the first wife,
Yes,
this deceased
yes,
contacted a second marriage,
yes,
right?
yes,
And from the first wife,
yes,
there are 6 children,
yes, Your Lordship.
right? The petitioner was the mother or foster mother, what is this? How she is the petitioner, how she is related?
She is the stepmother or foster mother of the late Bao, the deceased mother.
So, stepmother
Yeah, yeah.
of
Yes,
Bao Leno.
yes, yes, Your Lordship.
Okay. Now,
All the children.
she has got guardianship certificate petitioner,
Yeah.
right? Then succession certificate.
Yes, Your Lordship. Since
Now he is a government servant. Bao Leno was a government servant,
yes, Your Lordship.
right?
Yes,
The conditions for grant of pension
yes, Your Lordship.
is governed by any set of rules.
Yes, with succession certificate.
No. Say for in the state of Assam services pension rules.
Yes, Your Lordship.
Do you have any rules in the state of Nagaland?
Till now, not. No, sir. No, Lordship.
No,
It has
we
been,
don't think there is no existence of any pension rules.
specific state service, pension rules is not being in existence.
Yes, State Council, any state pension rules for government servant,
CCS pension rules.
CCS pension rules.
Yes.
Then in case a pension rule you follow by adoption, then which one will prevail? Which one will prevail? Succession certificate or pension rules? Pension rule. If pension rule prevails, then this judgment, which appears to be nullity on the face of law,
Yes, Lordship.
is the first wife if I normal or consistent rule in pension rules is that the wife is the first claimant.
Yes, Your Lordship.
So in that view of the matter, Teso Si Neo Leno will be the claimant as per law.
Yes, Your Lordship.
Then once he accepts, thereafter he distributes, it is a different issue. She can distribute. But what is the consistent view of the Supreme Court? You are seeking pension and all as a poster mother. But whether that your succession certificate will prevail over the pension rules. We cannot close our eyes. You may have a good claim on paper, but without ignoring the rules, we cannot issue a direction.
Yes, Your Lordship.
Check out day after tomorrow.
Bless you.
If you can come up with some authority, okay, otherwise. And what the stand of the
The basis, Your Lordship, the basis on which the petitioner is claiming pension, Your Lordship, is based on, we're saying that the deceased, Bao Leno, he was not a government employee, so he himself is not entitled. to
not
pension.
a government
No,
employee?
Your Lordship.
Let us see.
So, Your Lordship, if you go to read petition, page 30, Your Lordship, this is the appointment order, Your Lordship.
You have raised another complicated issue now. Page 32.
Yes, this is the appointment. Your Lordship, if you look at
This is not a body under state government.
no, Your Lordship.
Why state government is issuing an appointment order?
Your Lordship, this,
You have complicated the issue. Hmm?
Your Lordship, here,
I know ICAR is not a body under state government, perhaps. Indian Council for Agricultural Research. Is it not?
yes, Your Lordship. So this appointment was based on the funding received from the ICAR, Your Lordship.
Okay.
So the appointment itself is very clear, Your Lordship. The petitioner is not entitled for pension.
Those funding in case of.
Your Lordship, this matter has arisen out of MOU. There is an MOU between the Department of the Agriculture and the KVK. So based on the MOU, it has been clearly demarcated about the powers and function of the parties.
But then, where is the entitlement for pension?
Your
Okay, this
Lordship,
is one document, page 32. Okay, then what? Let us see one by one. In the interest of public, you would.
67.
No, let us go one by one, sir. No, all are starts with T, Leno. I am getting confused. Let me be clear with the facts. T, Le, O, Neo, Leno. You said stepmother.
Yes, Your Lordship.
Stepmother of Bao Leno.
Yes, Your Lordship.
Late Bao Leno. Okay. What is the divorce one? Divorce.
Your Lordship, if I may, Your Lordship.
1 minute. Let me clear with the names. Teso Sienio Leno. First wife.
Yes, Your Lordship.
First wife of late Bao Leno. Okay. Then Toso Vino Leno. Second wife.
Yes, Your Lordship.
Second wife of late Bao Leno. And all these children are Teso Sienio Leno.
Yes, Your
Right?
Lordship. Yes.
6 children or 5?
Fine.
5 children. 5 children. Okay. Now, first wife got divorce decree after the demise of her husband. Second wife surrendered.
Yes.
Surrendered
Yes.
her claim. And stepmother got guardianship certificate
Yes, Your Lordship.
and succession certificate. Guardianship certificate and succession. Okay. Now let us see the status of Bao Leno.
Yes, Your Lordship.
Yes, his service documents. Service documents first, then we'll go to the CCS rules. It starts from Miss Inaholi.
The
Page,
page
his,
52 of the repetition, Your Lordship.
this man died when?
Your Lordship, the death certificate is
38,
36.
38 March 2020. Died on
30th March
2020.
20. All right. Now let us see service documents one by one. Okay, page 32.
Yes, this is the appointment order. Your Lordship.
Krishi Bigyan Kendra. ICAR. Sanctioned in the scale of pay, sanctioned right so and so. Yes, post will be as per ICAR norm, PN allowances of increment will be debitable under plan budget division. There is no provision for pension.
Yes. The
Clear in the appointment order, sir.
appointment.
Page 32. Then page 33.
Is the promotion order. You got promotion to on page 34.
Promoted to next higher grade under the career advancement scheme. Where is his name?
In page 34, serial number 8.
Okay, initially appointed as training assistant,
Now he's promoted to technical officer.
technical officer. Okay. That is in the year? Which year, sir? 2017.
Yes, Your Lordship.
As a technical officer, he expired.
Yes, Your Lordship.
Okay. Now we have seen guardianship certificate done. Then declaration by Tosovino Leno, second wife. Then succession certificate for stepmother. Then divorce. Now, what are the basis of your claims? What are your claim? What you are claiming?
Debt, gratuity, and leave engagement.
Okay, debt, gratuity, and leave engagement.
Yes, Lord.
No pension. Because pension,
Yes,
you have to be a state government employee,
yes, Lord.
which apparently you are not, perhaps. Yes, let us see the stand of the state government. We'll come back to you.
Lordship, my relevant paragraphs are 5.
1 minute. Forest is CCSS. What is the full form of CSS?
Central,
Central Civil Service.
Central Service, Civil Service.
CCS. CCS. It should be CCS. CCS, I think.
Yes,
Para 5, you have read say CSS, no? CCS.
just for that. Central Service.
Then next para.
Next para is 8. Para 8.
So far, CCS pension rules, these are applicable to government servant appointed on or before 31st day of December 2003. So your appointment, whatever be the nature of appointment, was after 2003.
Yes.
So you do not come under CCS Pension Rules 1972.
There is another notification.
That will come. You are not under CCS Pension Rules 1972.
With regard to this matter, there is an MOU, Your Lordship.
No, we'll come to that. Otherwise, come to your page 48 or page 11 of the affidavit in opposition. Page 48 of your writ petition. Page 48. Read para 2, rule 2, application.
Save as otherwise provided in these rules. This rule shall apply to the government servant appointed on or before 31st day of December 2003, including civilian government in defense services, appointed substantively to civil services and was in connection with the affairs of the union, which are born on pensionable establishment, but shall not apply to railway servant, present occasional and daily rated employment, person paid from contingency, person entitled to the benefit of the contributory provident fund, members of all India services, person locally recruited for the service in diplomatic, consular, or other Indian establishment in foreign countries, person employed on contract except when the contract provides otherwise.
So you do not come within this rule because you were not appointed. Your appointment was 2007. On save as otherwise provided in these rules. So if you can show us that you come within 72 rules, then okay. Otherwise, you don't come under within this rule. It is clear. Now, where is the MOU?
Page 54.
Let us see. Type copy.
It begins from page 63.
Correctly typed?
Type copy page 63.
Correctly done, 2005.
Yes.
ICAR, it is a society,
Yes.
right?
Yes.
And Director of Agriculture, grantee.
Now,
Council and grantee have the following mandate. Following to act as a clearing house to provide, to look into problem. The project KCB has the mandate on farm testifying, organized. They have the following mandate to extend training in the hill sector. For the member council shall provide grant. Clause 5. For the project Krishi Bigyan Kendra, the ICAR will provide grant which includes salary assistance in respect of competent scientists and technical staff in different disciplines. So, and assistance of salary in respect of modest office staff necessary to support the scheme. Other things are not material.
Lordship in 7.
Page 67.
Yes, 7.
Staff treat the KPK staff at par for the purpose of privileged amenities and facilities permissible to other staff of grantee.
it has been specifically mentioned, and A2, and in A2 also. Your Lordship, may I please read? All staff of KVK shall be born on the establishment of grantee only. The administrative control over the staff employed under the scheme therefore shall be vested on the host institution. The placement of staff working in project, the termination of project shall be sole responsibility of grantee without having any liability on the council. So in this matter, appointment, transfer, promotion, all are the administrative under the control of the department, the host, and the salaries were paid by the ICAR, ICAR. So now they have to treat, as per this MOU, they have to treat the staff of KVK as at par with the state government employees. And they have agreed to this, and they have put their initial, they have already agreed, and likewise the four district, this project is being underway. So my claims comes from this provision. Apart from this, the minister in charge of the agriculture, union government, as well as the central government, the secretary, has specifically written to our chief secretary and the chief minister to treat the KVK's employees at par with the state government employee.
Come to page 67 also. Roman 3. Council. Council means ICAR. Come to page 72,
Yes, Your Lordship.
cross 15.
Yes, Your Lordship.
Council will not bear anything.
Yes, Your Lordship, after retirement. Once the service is over, till the service, salaries, everything will be paid to the incumbent. And once it is over, it is only to be done by the grantee, by the state respondents. And this has been stressed by through the letter in Annexure D, page 90. by the Honorable Minister of Agriculture, Farmers Welfare, Rural Development and Pensionary Raj Government of India. In page 19.
Adopt a new pension scheme. What is their response when you ask for this release of leave encashment, etc.?
The response is that they are not.
Government to
don't
the
have any
director.
liability to pay for pension.
With reference to subordinate is fine here with the attachment of the service benefits.
On page 78, that is my application. Then a forwarded letter has been made to the
What is Atari?
Atari is the headquarter of the ICAR in Northeast.
Mm-hmm. No, it is an abbreviation. It is an abbreviation.
Yes, this is in
What is Atari? Yes, madam, what is Atari? Page 83 of the writ petition.
Lordship, apologies, I didn't get your question, Lordship.
ATARI, page 83 of the writ petition. Now, this Krishi Vigyan Kendra authorities are making mention of
Agricultural Technology Application Research Institute. Can be
And-
seen in page 81, Your Lordship, the
which
page
is
81, Your Lordship.
Okay, Atari.
Yes.
That is in Rivoy, Meghalaya. Atari. Now, where are these government letters? DO number, third line and fourth line, paragraph, page 83.
We don't have this copy. This copy we did not receive. We received only through the
This sorry, page 83, third line and fourth line, two DO letters. And that is Government of India. To the Chief Minister, Chief Secretary by the Agriculture and Farmers Welfare and Director General ICAR, which is self-explanatory. It was enclosed. Where are those letters?
we received only the front page, yes, the annexure which were enclosed with the notice received. This has been given to the respondent, for the respondent to have the copy.
It is there. It is there, part of your document only. Then second I was 791. DO 104 AM. Page 90.
Page 20, you put your lordship, may I please read the.
I have read.
Lordship,
Page 91 also.
Yes, your lordship.
Your Lordship, this letter may not be binding, Your Lordship, and also, Your Lordship, the appointment order is very clear. And even in the OM, which the.
Appointment order was clear, where thereafter there was MOU. And MOU had clauses.
But this.
And you accept the money for salary. And there is an inherent condition that you have to bear the other things.
No, Your Lordship.
You have accepted merrily the MOU because you are getting the money. But when the time comes to release the benefits, service benefits, then you
Your Lordship, the
want to close your eyes.
MOU was.
An MOU then,
Behind the appointment order, Your Lordship. And Your Lordship, with regard to this,
whatever, then you have been granting him promotion and with scale of pay.
so much.
Scale of pay also.
Does not say that we have to pay pension.
But that has been.
We commit, Your Lordship, we have not committed to pay pension.
Then why you are signatory to the MOU with all those clauses? And that is a matter of interpretation. With all those clauses, treat KBK staff at par for the purpose of privileges, amenities and facilities permissible to other staff of grantee. And grantee is what? Government of Nagaland. Council is ICAR.
And also whether this document can be taken as a document of.
Which one?
The MOU.
MOU, you are a party to it.
Yes, Your Lordship, but this.
You are a party, is it not?
But as per the rules of executive business, Your Lordship, it has to be signed by a secretary, Your Lordship. Secretary. But this is signed by a director of agriculture, Your Lordship. So if we go as per the.
What is Gandhi? SAU, I don't know, State Agriculture University perhaps, state government, deemed universities, PSUs, other government universities situated in the state of Nagaland.
And Your Lordship, like your Lordship has already pointed out, Your Lordship, the petitioner, the legal right of the petitioner is also in question, Your Lordship, and if we go.
That is a different, but the question is, the person who died in harness, he left 6 or 5 minor children. Whatever may be the question, but question is regarding receipt of his the benefits for his long years of service.
But you have not committed for granting pension, Your Lordship.
Okay, you go through the provision and you find out other Krishi Vigyan Kendros, Lucas.
Your Lordship, even.
I'm not very sure.
And Your Lordship,
Your Lordship, even in annexure O, page 82, the director responded to the says, written saying that the grade of gratuity.
No, when the issue comes for disbursement, everybody is turning towards the other side, shirking their responsibility. That is what I have found. Both central government as well as state government.
Yes, sir.
So you go through again all the provisions. Right. I am not also sure who is to pay.
Yes, sir.
Because you are not a regular employee otherwise
Yes,
of the state government
yes.
to be governed by the pension rules.
Yes, sir.
You don't come under CCS rules 1972. You are not a regular employee. Mayor treating you with the same facilities may not make you a government servant.
Yes, sir.
If you are not a government servant,
Yes, sir.
maybe ICR and Krishi Vigyan Kendra might be an instrumentality of the state under 12, but that will not make you a government servant. Government servant is a different, and that ICAR is a society.
Yes, sir.
Find out the status of ICAR. Raise judgment. It is an instrumentality of the state, though it is a society, fully controlled by. Come up with better research.
Yes, sir.
Then we'll take up Friday. Right?
Your Lordship, what Tuesday, Your Lordship. Friday, I'll have personal leave.
Huh?
Tuesday.
Thursday.
This Thursday.
Let me also think it over.
And then also just for discussion, Your Lordship, the petitioner, the one of the sons of the minor son, he is already a major before
Okay.
on the day of the filing of the report.
Okay, 4 still remains.
So
4 still remains.
they are already a major.
4 are there.
So the legality of the petitioner is also.
The question is entitlement on the date of the death of the employee. Subsequent attainment of majority may not be an issue. Question of entitlement is will relate back to the date of his death. So that question will not come, I think. Will not stand in the way. And anyway, out of 5, 4 are still minor. But question is his status. Huh?
The wife is still alive, so maybe.
But have you come across that they are government employees?
So that's why I was also wondering.
Think it over, think it over. It is a difficult issue. Because, okay. We'll take up at 2. Mr. Takamasa. Mr. Yes, Mr. This shows and comes for the petitioner and Miss Ina Holi and State Council. As sought for executive by the Land Council for the party, release the case on Thursday. We'll think it over again. Not a simple issue, at least to me.
Yes, Kohima. This is all the recommendation on school. Sir, yes. Hello. Hello, is it interesting? Because that's what. It's the. Sorry, I beg your pardon. And. Into the room, I said, as a bias, who's the. Is your excellences now? Not one of us, once. I go, I already go. Oh, here, and I thought, oh, I'm not, I didn't go to Brown.
For hearing, item number 25.
Lordship, in the morning, I was wondering whether this item will be the last item. And there was, because of the weather, there was a big intention to pray for adjournment, but anyway. After watching the mentioning in the morning, my hope increased in very annoying. Lordship, this is the third round of litigation. The matter relates to cancellation of the petitioner's indigenous certificate. Lordship, it's a very, very unfortunate case where for the sins of the father, an innocent child has to face these consequences with all the social stigma and the mental trauma for the last 5 years. Before I go do the documents, since it is 3 rounds of the third round of the litigation, kindly allow me to narrate the facts in the gist. Doctor, the petitioner, her biological father's name is one Otoshi, and Sumi, she belongs to Sumi community of Kifri district. Now, my lord, the Sumis hailing from Kifri district are considered as backward, socially backward, and they are given reservation, job reservation, some percentage for employment for examination conducted under the Nagaland Public Service Commission. Now, her father, the biological father, Mr. Otoshi Sumi, who belongs to Yangzi Tong village from the Kifri area. He was a married man. He developed an extramarital affairs with one Mina from Nepali community, with she was having 5-6 children, and she was born out of that wedlock. Now her biological family refuses her aunt, the mother of Otoshi, wife of Oto, our father Otoshi refused to accept her. So when she was an infant, stillborn, her aunt, Yivili, who happens to be the younger sister of her father, took over, accepted her, decided to look after her. She was married to one O'Neill Ruva, an Assamese gentleman who was working as a 4th grade under the commissioner's office at Mukokcham. So from childhood, they were her foster parent, having the unfortunate situation of not being accepted by the mother of the wife of her father, her aunt or stepmother. Then she graduated, she was good in studies, she finished her post-graduation. In all her certificates, documents, her name is entered as Otoshi Sumi, the father. Now, she never saw her or met her mother in her life. Her whereabouts is also not known. So, Mala, unfortunately for me, in all her documents, her aunt who looked after her was mentioned as her mother. So it should be her aunt, father's younger sister. But then, for all practical purposes, Mr. Anil Rova, her uncle or foster, and her aunt brought her up for education, every purposes. And as a humanitarian gesture, Mr. Anil Rova had included her name as a beneficiary in the pension in this pension paper, because for all practical purposes, she was treating her as her eldest sister without she has got 2 younger sisters, 2 daughters. That was the situation. In course of time, for reasons best known to them, Mr. Otoshi had adopted Amir Ruva's daughter for the purpose of employment, whatever, but then that was subsequently set aside. So that is also there. Then she appeared for the Nagaland Public Service Commission exam sometime in the year 1999, and she was declared successful for the post of Secretary Assistant. Thereafter, Mala, serious complaint from the student community and social organizations of the Sumi community from Kifri district that she is not that she is not an indigenous inhabitants of Nagaland, and complaints were lodged. Accordingly, a verification was conducted by the Deputy Commissioner Kifri, and on the basis of the fact that then the students and the social society groups demanded for DNA testing. it was objected. Then, Lordship, on the basis of the evidence, fact that her name is included in the pension book, service book of Mr. O'Neill Roba. On that ground, her indigenous certificate was cancelled by the Deputy Commissioner Kifri, who is the competent authority. And in that view of the matter, her selection in the NPSC was also given abeyance. It was also proceeded, and one private respondent hailing from that area, who was second in order of merit, was given the offer letter in her place. Accordingly, Lordship, a writ petition 111 of 2022 was filed before this honorable court, and this honorable court, having come to the conclusion that the principle of natural justice was not followed, proper opportunity was not given, only on the basis of the pension paper of it was done accordingly by judgment order dated 22/12/2023. It was set aside, giving a direction that proper due process should be followed by the commissioner by giving up by taking evidence. And then the judgment says, subject until that it is decided, the post will be kept back. Secretary of State. Thereafter, Lordship. So accordingly, it was done. Then thereafter, Lordship, the evidence, the Deputy Commissioner conducted for all the parties, and proper evidence was done on 2011-2021 and 4/12/2021. So all the parties concerned deposed before the inquiry before the Deputy Commissioner Kifri. And Lordship, that time, it was reiterated and insisted by the other side, by the that for DNA testing. So the Deputy Commissioner passed an order directing that there should be DNA testing of O'Neill Roba, the Hotoshi, and the petitioner. So we came before this honorable court challenging the decision of the respondent authorities for DNA testing. Filing, and this honorable court, Lordship, the WBC has passed a judgment that the DNA testing was set aside because it is not voluntary, Lordship is aware. And Lordship is well aware that the judgment of the Honorable Supreme Court is also very clear that on the issue of paternity, court does not encourage posterity, and presumption is in favor of the petitioner. That is the judgment. So, Lordship, the learned single judge of this honorable court set aside the direction for DNA testing and give a direction to the Deputy Commissioner Gifri that on the basis of the evidence already adduced, he should pass a speaking order. Accordingly, Lordship, the direction was issued, and by an review order dated 31/5/2024, the London Deputy Commissioner passed an order reiterating the earlier decision. And Lordship, that my setting aside my indigenous inheritance certificates. During the pendency of the writ petition, the private respondent who was recommended in my place in the interview in the first interview, he was subsequently recommended and selected in the subsequent writ petition. Accordingly, in the first two writ petition, he was completed as a private respondent, but during the pendency of the second writ petition, he came before this local court and make a submission that he's accepting the offer of the second interview. Accordingly, he does not wish to pursue. Accordingly, Lordship, in the third writ petition, Lordship, we did not complete him because the issue is we're telling the finding of the deputy commissioners. Deputy commissioners, whereby the earlier decision of that I'm not indigenous has been reiterated. Now, thereafter, the private respondent in earlier has been appointed in view of a subsequent interview, but in the affidavit filed by the BSc and the government. Now it has been found that in view of the new order passed on 31/5/2024, Lordship, his seniority was reviewed to the interview, to the first interview. that will be there. I'll come to that later. So, my lord, that is the lordship, sums and substance of the case. So, my lord, keeping that as a background, I will quickly go through the documents. Sufficient to the limited, my lord, I'll be reading relying more on the documents than submissions. My lord, item 34, page 34 is the date of birth certificate of the petitioner. Lordship, name is Lili Sumi. She was born in Mohokchong. Then date of birth. Then father's name is given as Otoshi Sumi and Yuvili Sumi. The younger sister of her father, Yuvili Sumi, is given as her mother's name.
When it was obtained?
My lord, Lordship Nikan is 12/5/96 below on the right side. Then Lordship, then
Was there any order of the magistrate to issue such a certificate?
for this, Lordship, there's a process where the Economic and Statistics Department, on the basis of the birth from the concerned medical hospital, we go and apply and obtain. There's a process for verification by the Department of Economics and Statistics.
But if it is more than 1 year,
My lord,
that is the statute.
my lord, that is a simple process.
No, the
Yes.
statute, the registration of births and dates
Yes,
act, I think 1900 so and so. If
but
the birth is to be registered within a period of 1 month,
yes,
a certain thing within 1 year, and it is goes beyond 1 year,
yes,
then there has to be a specific order of the magistrate.
my lord,
Now, this is statutory provision. That is why I am.
I'm fully concede to your lordship's view, but this is a document not disputed by anybody. Then the admit card is her matriculation admit card, lordship. So, lordship, here also father's name and mother's name is given, and date of birth same 5th January. Then, lordship, this is the class 12 admit card at page 36. Thereafter, lordship, the Aadhaar card, I'm skipping, lordship. Then, lordship, page 39, this is the admit card for her examination to Nagaland Public Service Commission, where it is mentioned same thing, and that then, my lord, certificate of indigenous inhabitant certificate of indigenous inhabitant of Nagaland, lordship. My lord, registration number. Then Lady Sumi, Hotoshi Sumi is the father's name. The village name is Yongzitong, under KP district. And lordship, it was issued on 9/6/2017. Lordship, you can appreciate the fact that prior to that, it was also an indigenous inhabitant certificate was issued. But sometime in 2016, state government changed the format, and you were meant to reapply accordingly. A new process was done, and she was issued on 9/6/2017. No dispute about that. Only later on, lordship, I will come to this issue. So this is a point of attention. Then, my lord, her ST certificate based on this is the next page. Devi Sumi, Otoshi Sumi, Yangzidan, Kifri, all same, lordship. Just so this is the documents. These are the documents on the basis of which she is claiming, lordship. Then, my lord, a result was declared on 19 December in PSU result, and lordship, at page 43, serial number 36. She was declared successful to the post of Secretariat Assistant for Backward Tribe Sumi Kifri, page 36, serial number 36, lordship. Then, my lord, there was a corrigendum on the issue, which is at page 44 on 22nd May, lordship. Here, her name is her name at page lordship 47, serial number 36. After this, lordship, as I said, complaints in longer complaints, and the lordship, the first order passed from Deputy Commissioner Q3 4/2/2020. My lord, lordship Nikandi along at page 48. May I read one? 29/1/2020. The proceedings was conducted under the chairmanship of Deputy Commissioner as per the summon order dated 23rd January 2020 and the matter pertaining to Indigenous Independence Certificate, ST Certificate, Backward Tribe Certificate of Navy Sumi Unified Service, objection by the Eastern Sumi Moho and Kifri to some district Sumi student using unit. After briefing the details of the case, the Deputy Commissioner invited Ms. Lodi Sumi to submit a statement in support of her claims. Ms. Lily Sumi produced all her educational documents and submitted she is the biological daughter of Hotoshi Sumi and was never an adopted daughter. Mr. Hotoshi Sumi, who claimed that Ms. Lily Sumi is his biological daughter, has submitted the circumstances leading to the birth of Ms. Lily Sumi. I was legally wedded to Ms. M.S. Lukili in the year 1976 and had 7 children. However, out of wedlock with another woman, a child was born, but my legally wedded wife refused to take in the baby. Therefore, since the baby was my legitimate daughter, I requested and entrusted my real sister, Miss Ibili Sumi, wife of Unil Rova, to look after and raise her. This is the reason ground of confusion and has given enough room to doubt about the status of her indigenous certificate. Vote. The council chairman of Yongsitan, that is Sri Hotoro Sumi, stated that Hotoshi Sumi and family lived in Sumibuto to a bona fide citizen of Yongsitan village. Therefore, since Hotoshi was not known to him personally, he asked him to submit all relevant documents to certify the forms while applying for certificates in respect of Didi Sumi. Satisfied with the documents produced, the form was certified and recommended to enable her to obtain the certificates from DC's office. Eastern Sumi Ho President and General Secretary stated that the district authority has no fault in issuing the certificate to Didi Sumi as the form was certified and recommended by the village authorities. However, they contested that if Sumi is the biological daughter of Hotoshi as claimed by her and her father, the Oho will prefer DNA listing about the father and daughter. They further stated that the Oho stood and shall stand for justice and Sumi members of every Sumi member of its organization. He further asserted that instant case has been raised by the also that junior indigenous Sumi of Kibri district is not victimized. In conclusion, the commissioner clarified that recommending for DNA listing of both the father and daughter is not within the power of authority, and therefore clarified that she will forward the findings to a higher authority in the government will take final decision in the matter. So then the signatories, whoever has participated, 4950 are there. So it was in presence of the complainant, all the parties. Then, Lordship, surprisingly, the new order 16 June 2020 was issued by the commissioner cancelling my indigenous mayor Lordship. Consequent upon the complaint filed by Imam key frequent some district Sunni students in the government to notify the indigenous certificate that she does not belong to the indigenous Sumi tribe of Kifu district and the personal and necessary reforms by order dated such and such. And upon studying all documents and facts pertaining to the case, the following have been found and concluded. 1. Those Sumi has listed her father's name as Kotoshi Sumi of the Incident Village Kifu district in her background, including indigenous certificate and such issued. Yet Kotoshi Sumi was not listed has not listed her name as his daughter in his pension payment order dated 26/2/2015. He has listed only his wife locally at Sumi and stated his children are overage, even though Miss Sumi was an unmarried female and eligible at that time to be included in the Hotoshi Sumi's BBO document. Also, documents of Bibi Sumi list Yivili, wife of Nuruba, as her mother and who, as per Aadhaar and IPIC, card submitted appears to be the biological sister of Hotoshi, as they share the same father's name and Zituki's Sema. So, Lordship, the Deputy Commissioner has examined the documents of her father and her aunt, and there in all the documents, their father is shown as Zituku Sema. Also in the pension papers of O'Neill Riva, as per the commissioner's letter dated such and such, O'Neill Riva has retired as sweeper from the office of Deputy Commissioner Mokkyong on 28/2023 and clearly indicated his family as Srimati Givili, Srimati Kavitoli, and Miss Livi, daughter. From the above documentary evidences, it appears that Miss Lovisoni is a daughter of Sri Onyolova and Hotoshi as claimed Onyolova and not Hotoshi Sumi as claimed by her. Also, along with Miss Lovisoni, Miss Libituli and Gabituli, who have named their father as Hotoshi Sumi, had obtained indigenous certificate at the name at the same time from the Office of Deputy Commissioner Preferred. However, it may be noted that Gabitoli is also named in Onyolova's pension documents as one of his children along with Libisumi. In addition, all of them have given their mother's name as Yuvili. Whereas the pension documents of Sri Hotoshi clearly list his wife of Lukuli et Sema, which clearly casts a dot on their credibility as the indigenous Sumi of different. It is also highlighted that the said certificates were issued from the Office of Deputy Commissioner Kifui on the strength of verification done by the then Village Council Chairman Yangzidang Village, Putukusumi, in the official obligation and from the issue of indigenous certificate where it clearly states that he shall be responsible for any false statement information furnished. This shows the careless attitude of village authorities and failure on their part to perform their delegated assignment, diligently well verifying indigenous evidence, credibility of the applicants, thereby misleading the verifying officers and issuing authorities. Therefore, based on the company documentary evidences, indigenous certificate identifying Livi Sumi and Naga of Kifli district issued by such and such is hereby cancelled. Also, Kavituli is also named as the children of Nurova in his pension documents, therefore based on the compelling evidence, Kavituli's indigenous certificate, it identifying her as Sumi Naga Kifli district is also cancelled. Also, Kavituli who also named her father as Hotoshi Senipat also lists Sri Vituli, wife of Nurova, as his mother in her documents, which also casts a doubt on her credibility and thereby her indigenous certificate identifying her as Sumi Noga is cancelled for further scrutiny.
Who is Lobituli?
My lord, the last two are the daughters of Onyolova. I mean, maybe he tried to obtain indigenous certificate through her uncle, so it was cancelled. And they have not come again to challenge it. So, my lord, on the basis of
We have seen just for my understanding. This page 48 or in order also, it mentions about indigenous inhabitant certificate,
yes,
scheduled tribe certificate,
yes,
and backward tribe certificate.
yes,
What are the significance of these three certificates?
only on the basis of
So far, I know scheduled tribe certificate, it is under the constitutional order,
yes.
under the constitutional order.
Gotcha.
Now, what are the source of issuance of this backward tribe certificate and indigenous inhabitant certificate?
My lord, on the basis of this two document, only the person who is an indigenous inhabitant of Nagaland is entitled to for the 100% job reservation for appointment.
What is the source?
My lord, one should be,
One should be, but where it is mentioned? That scheduled tribe certificate, that I
my
know.
lord,
This is under the constitutional provision.
my- I'll bring it to the, if necessary, I'll bring the required notification.
Because
There's a notification.
then if scheduled tribe certificate, now as I have understood, out of all the scheduled tribes,
Yes,
few are out of them backward.
yes.
Where is that?
My lord, I have not brought the notification, but I can produce a notification. There is a notification of 77. I'll bring it.
Okay, and what is indigenous inhabitant
Yes.
certificate?
Yes.
What is the source? It is traceable to which one? Any statutory provision or office memorandum of what?
Office memorandums. Office memorandums.
Office memorandums. Basically, no statutory form.
No, only office memorandums.
Because scheduled tribe certificate has a constitutional provision, right?
Not.
It is backed by a constitution provision, scheduled tribes order
Not yet. Not yet.
under Article 341 or 342.
My lord, I will kindly allow me to produce I'll bring the
Because
produce notification.
law regarding scheduled tribe certificate and whether one falls under scheduled tribe or not, the procedure is well defined.
Not yet. Fine. No.
Well defined.
No issue, Lord.
Right. But there is no procedure to find out.
My lord.
I have to be informed,
Yeah.
right? that regarding backward tribe certificate or issuance of indigenous inheritance certificate, because for scheduled tribe any question arises. This is caste certificate. Any question arises, yes, it is a deputy commissioner, and thereafter any dispute arises, it is the state level scrutiny committee.
Lordship, to save time, I'll produce the executive the notification, Lordship. Because certain criteria are laid down.
Yes.
My lord, yes.
Because why I am saying may be relevant, and various judgments flowing from there and Government of India notification.
Yes.
Just for a minute.
Yes.
If the child is brought up in an environment is a very relevant factor.
Lordship.
So for suppose mother is scheduled tribe, father is unreserved.
Yes.
If the child is brought up in the environment of his father, then it is different issue. If the child is brought up in an atmosphere where mother is, then it is a different issue. Just to because we don't have any set procedure regarding IIC or BTC.
Yes.
For the moment, subject to your appraisal.
My lord,
I don't know.
my lord. The only, my lord, to save on that issue, my lord, kindly allow me to produce a relevant notification so that will keep me safe a long time of.
Any procedure is laid down.
Yes, laid down.
Laid down
Yes,
in the executive instruction.
yes,
Good enough.
yes.
We have to test this along with the imperial order.
Lordship, fine. My lord, kindly allow me to produce that. So, my lord, this was the Lordship, may kindly appreciate the fact that at page 51, only on the basis of the pension documents of one of his under Onil Ruba, the deputy commissioner had come to the conclusion that that Onil Ruba is her father.
Two factors, Hotosi not including her
Yes,
and Onil Rava including her.
yes.
Two factors.
That's why I'm saying only on the basis of the pension documents after two. Only on the basis of that.
So he is finding it supplemental to each other,
Yes.
supplementary to each other.
So thereafter, Lordship,
Hmm.
thereafter, my lord, at page 53, 30th June 2020,
Hmm.
Lordship, in my place, the paper is one serial number 37 was appointed in my place. In view of the fact, Lordship, that my indigenous inheritance certificate was set aside. ST certificate was set aside by the 16th June 2020 order.
So it has been changed.
Yes,
Okay, partial modification.
yes, partial modification.
Okay.
Then, my lord, page 55. The WBC 85 of 2020 was filed before the Honorable Court.
Hmm.
Then, my lord, this is the judgment issued. My lord, to save time, my lord, if your lordship may kindly see at page 61, the order to which I have referred in all the documents, my lord.
Hmm.
My lord, lordship may kindly see from page 59, paragraph 6.
Hmm.
All the documents where issues which were explaining is about the documentation is there. The Deputy Commissioner's order, which was under challenge at page 61. So to save time, I'm not reading it. But kindly allow me to read from paragraph 7. It appears from the submission of the learned counsel appearing for the parties seen from the contents of the Indian order that the same was passed on mere perusal and partial consideration of the documents submitted by the parties involved. Further, it also appears the Indian order was passed by giving so much weightage only the pension payer of Nurova, the husband of Italy, but totally ignoring the other documents. Since there was a strong play on the part of the petitioner that she was born out of extramarital affairs of her father with another woman, and therefore before she attended at all, the name of her father's sister was hindered in their mother's as her mother in the educational credentials. And since it is a fact that there was also a strong claim from Bushi himself, thus he so
1 minute. This Evile Sumi is Onil Raba's wife.
Yes,
Her name has been
yes,
shown as mother.
yes, who is the sister of.
Actually, the sister of Hotose or Hokosi.
And from the earlier documents, the deputy commissioner's order, on verification of the deputy commissioner, in page 51, there's a particular paragraph in all the documents, Hotoshi and Yevide, her father is said. That finding is there. Married. Further, it also appears that the Indian order was passed by the giving so much weightage only the pension papers of only Roba, the husband of Yevide, but by totally ignoring the other documents. Since there was a strong claim on the part of the petitioner that she was born out of extramarital affairs of her father with another woman, and therefore, before she obtained adulthood, the name of her father's sister was entered in her mother's as her mother in the additional credentials, since it is a fact that there was a strong claim from Hotoshi himself that he is the real father of the petitioner, which was supported by the chairman and secretary of the village council respectively. The deputy commissioner Kifri should have recorded from evidence of both oral and documentary, and thereafter only through the conclusion whichever way the evidence supports. However, it appears from the appeal orders that nothing of that sort was done, but based only on the face value of some documents, the fate of the petitioner was decided. The issues involved here are crucial to the very identity and future of the petitioners besides her career. Therefore, it requires careful consideration of all the evidences that are available or can be produced by the petitioner and the opposite parties. However, sadly, it appears on the face of the record that the commissioner in a hurry and arbitrarily had drawn the conclusion and cancelled the indigenous certificate of the petitioner. Furthermore, in such cases by which the life of a person can change drastically, any authority responsible for taking such a decision is bound to give sufficient opportunity of being heard to the person concerned. The right of being heard does not mean a chance of mere appearance of a person once or twice. Rather, it includes giving an opportunity to produce all evidence, both of oral and documentary, to prove one's case. But in this case, on the face of the record, it appears that such opportunity was not given to the petitioner. This amounts to denial of right being heard of or violation of principle of nature of justice. In a democratic system of governance, the right to be heard of a citizen is an component of ensuring fairness and equity in administration. It is not possible to imagine maintenance of fairness and equity in administration without it. Therefore, in administration, it should be ensured that this principle of law is upheld at all costs. Viewing the Indian order of the commissioner free by taking into consideration the admitted facts and circumstances of the case, given in the preceding paragraphs and the principle of law stated above, this court is of the view that the same cannot be upheld. Therefore, it is quashed and set aside in respect of the petitioner hearing. Consequently, the petition Commissioner Kifri is directed to conduct a thorough inquiry by giving all the stakeholders or the parties involved the chance of producing their evidence, both oral and documentary, and of being heard, and therefore to a conclusion supported by evidence so produced. This wish should be done within a period of 3 months from today, since one of the posts of secretary assistant cannot be filled up until the commissioner take a decision. As for the second impugn of notification, there is such and such by the issued by the DSC. The same shall remain suspended till the commissioner comes to a conclusion and the issue of the petitioner's indigenous identity. So this is the order. Accordingly, the judgments of the order of the commissioner at page 51 was interfered to give us. Then Lordship may kindly come to page 65. Next page. In compliance, Lordship.
Yes.
Lordship, accordingly, my lord, in finding a reference to subjects I know, your letters that I am submitted here with the minus of the proceedings in respect of such and such. So, my lord, the deputy commissioner accordingly conducted the inquiry. My lord, Mary, my lord, this minus evidence will be crucial to the outcome of this case. Minutes of proceeding with regard to such and such. Venue, Deputy Commissioners Conference Hall, date 20/11/2021. Deputy Commissioner Kifri verified the original documents of Ms. Bibi Sumi and took attendance of all the stakeholders where the following persons were absent: O'Neill Ruba, Mina Kotoko, ex-Village Council Chairman, Youngstown Village. Statement of Hotoshi Sumi. The following are the statements of Hotoshi Sumi that Mina is the mother of dead Bibi Sumi, who abandoned them after the birth of Bibi Sumi. That Yuvili is her biological sister who raised up Bibi Sumi. Three, that he doesn't know anything about the whereabouts of Mina, and hence he can't bring Mina.
This
to
Mina is first wife or second wife? Or
The
Nepali wife?
Nepali wife.
Then how, huh.
My lord, she married one wife, never divorced.
Then how Ivili is her biological sister?
My lord, Yuvili is the wife of Unil Ruba, and Yuvili is the biological sister of Oposhi. That is the
Right, that is a wrong statement.
My lord, Yuvili, that
Oh, is his.
My lord, this is the statement of Oposhi, so he's saying it is
Okay, okay,
his biological sister.
okay. Hmm.
That Kavitoli and Luvituli are not his biological daughters, but daughters of Unil Ruba, that he has 12 children. So this is the statement of Oposhi.
Hmm? Anything but whatever don't mean. That Kavitoli. Yes, yes.
May I proceed, Lord?
Hmm.
Then statement of Devi Sumi, the petitioner. The following are the statements by Devi Sumi. One, that she filed a petition with the Gauhati High Court to revoke the cancellation of her ST and Indigenous by the 10th Deputy Commissioner, which was based merely on pension waivers of Omni husband of Ivili. One, that she is the adopted daughter of Omni. Three, that Mina is her biological mother and her biological father is Otoshi Sumi, who has been living in Bukchung for the past 29 years. My lord, since childhood, since birth, she was living, born and raised with Anil Ruwa's family at Bukchung, where he was posted as a sweeper. On being asked by the deponent why she applied indigenous certificate only in English.
This Anil Rava is scheduled tribe, otherwise.
My lord, I'm not aware. I'm not sure. I'm not aware of that. But then, my lord, scheduled tribe is also there, but the most important issue is the indigenous certificate.
No, right.
Yes, but
I know, but these are all correlated.
My lord, I don't think so. I'll verify, but as per my information, he is not.
Rabha is not unreserved in Assam.
Yes, so.
I don't know,
My
but
lord,
whether they are OBC or ST, that I know.
well, Rava, you know, the lordship will know better.
No, Rabha is not general, I say.
Yes.
Rabha might be ST also. Maybe ST.
My lord, can you allow me to receive instruction? Because
Because these are main issue. Firstly, one has to be scheduled tribe.
yes,
Thereafter, one has to be indigenous inhabitant.
yes,
And third one is what?
backward,
Backward.
right?
Backward.
Backward should be hailing from Kifi. So our village matters.
Huh? Backward.
Backward.
What is because see, Mr. Takamasa, I am not very conversant with this backward tribes out of all tribes. Unless you give me the proper documentation.
Sure. The Sumis the rest of the Sumis are considered as forward community. They are not eligible for reservation within the reservation in Nagaland. There's a reservation for backward tribes in Nagaland. Now, Lordship, for Sumis hailing from Kifri district, they are considered as economically backward, so they are given 4% reservation in employment.
Can you provide the document? Unless I forget.
I'll bring.
Because otherwise I'll forget.
No, I'll bring those.
Because it will create confusion.
My lord, I'll bring the documents so that kindly allow me to bring all those documents and place it on record. That will save the trouble.
Because I came to know that out of the tribes, 6, I think, Sangtam and a few, 6 are given reservation inside reservation.
Lordship, the few pockets from
Right.
of Sumis are given 4% reservation.
So, is there anything, any document on record here? Yes, Mr. You have brought any record?
No, my lord.
No documentation regarding
Yes,
that.
my lord.
I'll bring the records. Because earlier it was, with due respect, it was done before Honorable Justice Sertu and Honorable Justice Alessio. So all these issues, your conversion, so.
Dear God, I am not.
I have realized now. I have realized that I have used those documents. I agree, Lord. Earlier 2 rounds, it was very simple because you're more very conversant on this issue. So straightforward, we went to the merit. I'm not going to that side of the issue which your Lordship is raising, but very pertinent. So I'll kindly allow you to place the documents.
Because she is saying Mokok Chang for the past 29 years.
Yes.
So I don't know.
She
So
was.
whether she will get the benefit or
The
not.
question is, that title comes through her father.
Lineage comes through her father, but if she has been brought up by others, that is a relevant factor in case of scheduled tribe also.
Yes.
Now, if Anil Rabha does not belong to scheduled tribe, if he may be a scheduled tribe, just a minute, what are the questions coming up in my mind? Let me be frank. Anil Rabha may be a scheduled tribe in Assam, but he may not be treated as a scheduled tribe in Nagaland. And if that is so, her upbringing for 29 years under the tutelage of Anil Rabha will amount to loss of her identity as a scheduled tribe. This is the law laid down by Supreme Court.
My line of submission would be logic. I am only confining to the 2 judgments passed by the Central Court, and I'm only confining the evidence recorded for the moment. Thereafter, Lordship, if your Lordship desires that we go to the wider issue, then kindly allow me.
That is not wider issue for me. It is the most pertinent issue.
Yes, because the direction of the single judge was to take proper evidence from
Evidence.
and according to this evidence is taken, I'm only relying on that for a moment.
Because why I am saying that this kind of evidence is have been laid down for caste certificate also, right from Kumari Madhuri Patil, Supreme Court, and that has tested the time of law for last 40 years. This kind of inquiry. That is why it is coming in my mind. Yes.
Thus, she filed a petition to revoke the cancellation.
We have read up to 3.
That she is adopted daughter of Nilova. That 4, I'm being asked by the deponent why she applied ST Indigenous certificate only in 2017. She replied that her application for Indigenous certificate in 2000 was asked by the director of the ANR notification in 2007 for replacement of the old form to the new form. That under representation submitted by Eastern Sumi Ho Kifri District Concerned Student Union, it is stated that he had a meeting with the village council Yongzit where he concluded that her Indigenous certificate is TOEFL, whereas on the letter submitted by Yongzitong Village Council, it is written that she is a bona fide citizen of Yongzitong Village. This is her statement object. The statement of Nibili, sister of Oroshi, wife of Omniro. The following are the statements made by Nibili. 1. That Hutoshi Sumi is her biological brother, whereas Nibi Sumi is not her biological daughter, but she is simply the foster parent. But she is simply the foster parent of Nibi Sumi. 2. That the Eastern Sumi Ho visited her place to verify and check the genuineness of the indigenous identity of Nibi Sumi, but did not find any substantial records and documents. That is the complainants. Then statement of Simon Aomi, uncle of Nibi Sumi. The following are the statements made by Simon Aomi. 1. That on 29 January 2021, 2 parties had a meeting in the presence of the Deputy Commissioner Kifri, where they agreed to settle the matter and that she would declare in the newspaper that Nibi Sumi was born out of wedlock. However, Hokushi did not mention the statement that Nibi Sumi was born out of wedlock, while declaring the newspaper on the personal request of Nibi Sumi. After the press release by Hokushi, the General Secretary of Eastern Sumi Ho during a telephonic conversation with Sumi Ho, Simon Aomi stated that Eastern Sumi Ho had identified a witness in Hokchon to confirm that Nibili was pregnant with Nibi Sumi. This was the statement, but then that witness never came. 3. That the Eastern Sumi Ho was not satisfied with the press release And hence the Eastern Sumi who traveled to Mokokchung to check the reports and the genuineness of the indigenous identity of Livi Sumi. During that time, Honorable clearly mentioned to the officials of Sumi, Eastern Sumi Ho that Livi Sumi is not his biological daughter. However, Honorable mentioned Sumi is a nominee in his pension papers out of compassion. I'm being asked by Eastern Sumi Ho why they were fighting the case only for Sumi Ho and not for the Vituli and Gavituli. Sumin Alme replied that Hotoshi is not the biological father of the Vituli and Gavituli, but Hotoshi is the biological father of Devi Sumi. Hotoshi has been mentioned as the father of Gavituli, and Gavituli and the ST indigenous documents of the Vituli, and Gavituli because Onurava has been adopted by Hotoshi. Statement of Vituli, daughter of Hotoshi. The following are the statements made by Vitoli. That is one of the daughter of Hotoshi, the step-sister of Shin. One, that Mina gave birth to Livi Sumi when Vitoli was 12 years old and she can clearly remember it. Two, that during the pregnancy of Mina with Livi Sumi, Hotoshi's wife inquired from Vivili, the sister of Hotoshi, to confirm if Hotoshi is the father of the baby, to which Vivili replied in the affirmative. Three, that Vitali was born in the presence of Yevili and Vitali. So her statement is that her stepsister was born in their presence. Statement of anatomy, the president of the students. One, that he submitted representation to the government to notify the NBSC results and appoint a bona fide citizen in place of Vigisumi. Two, that fully supports all the representations submitted in relation to the case. Three, that in the pension paper of Ongilova, Vigisumi is mentioned as his daughter, whereas Vigisumi is not mentioned as a daughter in the pension paper of Otoshi, as pointed out by the Mongol. That Otoshi declared all his children as age when she could have mentioned Vigisumi. Five, that Vigisumi is not indigenous independent of Sudong village. Five, that Vivili is a biological mother of Vigisumi, and hence Otoshi cannot be the biological father since Otoshi is the biological brother of Vivili. Statement of Yehetu, family member of Vivisumi. The following are the statements made by Yehetu, members of Vivisumi. One, that Hotoshi had extramarital affair. Vivisumi was born out of wedlock. One, Vivili is not the biological mother of Vivisumi. Statement of Suga, the student's assistant general secretary. The following are the statements made by such and such. One, that the SSU fully supports the 16th January order, June order passed by the deputy commissioner. Two, that the village council chairman, Youngstown village, issued no objection certificate to Hotoshi stating that he is a bona fide citizen of Youngstown village based on erroneous name in the electoral roll reports. Statement of Kahotu, advisor Suni Ho. The following are the statements made by Kahotu's Yutami advisor. One, that Hotoshi claimed that he has 11 children in the High Court, whereas he is now claiming that he has 12 children. Two, that during the meeting with the deputy commissioner Kifri, Hotoshi claimed that in 1992 he was posted in Ocean, but as per office report, it was found that he has been transferred to Zimbabwe. One, three, that there is a witness in Ocean who can testify that Vivili was pregnant with Bibi Sumi. That witness never came. Statement of Legislative President Eastern Sumi Ho. The following are the statement made by such and such. One, that there were several complaints about the indigenous identity of Bibi Sumi after declaration of NBC results. Therefore, we tried to verify the genuineness and having unable to come to a conclusion, keep representation of the government to settle the matter. Two, that the matter should be settled either through customary court by taking oath or through DNA testing. It's statement of PPC Joint Secretary Sensumi Mogo. The following are the statements. One, that he fully supports the regional statement in relation to the case. Statement of H. Otto, GV of Yangzidang village. The following are the statements made by Yehudu GV Yangzidang village that one, that NOC was issued to Hotoshi because Hotoshi is a bona fide citizen of Yangzidang village. The deputy commissioner scheduled the next hearing on 4 December 2022 with the petitioner and the deponent along with the following absentees. That worship, the 70, page 70, 71, 72 are signatories of who were present that day. Then the second hearing, worship at page 73.
Yes.
May I worship? Minutes of the proceedings in respect of on 4th December 2021. The district magistrate welcomed the members and took attendance of all the stakeholders involved in the case. Statement of Bibi Sumi. The following are the statements of Bibi Sumi. One, that Munil Rupa is not her biological father, but her foster father. Two, that Yubili is not her biological mother, but her foster mother. Statement of Munil Rupa. The following are the statements of Munil Rupa. One, that he belongs to Swiss community. Two, that Mrs. Yubili is his wife, that he has 5 children. 4, that Utushi is biological father of Bibi Sumi, and that he doesn't have any information about the biological mother of Bibi Sumi. 5, that he was posted as a sweeper in the office of the deputy commissioner at the time of his retirement. 3, that he retired in February 2003. 7, and been asked why he did not mention his eldest daughter Mukali as his nominee in the pension paper. He stated that all the pension related works were done by his wife, therefore the nominee was also entered by his wife. Statement of Bibili. The following are the statements of Bibili that she has 5 children. 2, that and being asked why he entered Kavi, Lubi, and Livy as nominee in the funeral of his pension paper. He stated Kavi and Lubi are the youngest in the family, and when Livy being her adopted daughter was entered as nominee since he was by some officers to enter the youngest in the family. Statement of Simon, Kotoshi's younger brother. Following are the statement of Simon. 1, that the petitioner would not bring Nina family members to the court because they had no information regarding Nina. Statement of Potolo, ex-village council chairman of Yanisikan village. Following are the statements of Potolo. 1, that he was the village council chairman of Yanisikan village from 2017 to 2020. 2, that he attended his signature in the Indigenous form of Bibi Sumi when he was the village council chairman. 3, that Yeshivi, family members of Hotoshi Sumi brought the Indigenous form of Bibi Sumi since Hotoshi was staying in Ripoto at that time. 4, that he appended his signature after referring the electoral rule serial number 157 where Hotoshi's name was entered as Z Heavy. On being inquired by the deputy commissioner about the mismatch of the name, it was stated that Hotoshi was also known by the name Z Heavy. Statement of Hotoshi Sumi. The following are the statements of Hotoshi Sumi that he was also known by the name Sihebi, which he changed to Hotoshi Sumi in 1971, that he was about 18 years in 1971, that he does not have any document to support that he was also known by the name Zihebi except the affidavit declaration. Statement of Ihuto Echibi, Kibia Incident. The following are the statements. The Hotoshi is the biological father of Bibi Sumi, that he knows Hotoshi from earlier days, when he is also known by the name Zihebi. Statement of Yangzitang villagers. Yangzitang villagers submitted a joint declaration stating that Bibi Sumi is the biological daughter of Hotoshi Sumi. Statement of Hoike L. Yitu, father of Pikitu. Pikitu is the private respondent who was subsequently appointed. The following are the statements of Hoike L. Yitu. 1, that we had a telephonic conversation with TBO Ihoto on the day of declaration of the BSc results, wherein Ihoto clearly stated that Bibi Sumi is the daughter of Bibili and Omil Rama. Statement of the another president. The following are the statements that teachers were also confused about the indigenous identity of Bibi Sumi and therefore he suggested to forward the matter to the government. Statement of El Hoketo Yiptoni. The following are the statements that after the NPS result was declared, Yangzida villagers circulated information through WhatsApp that Bibi Sumi is not Sumi by blood. After hearing all the stakeholders involved in the case, the district decided to conduct DNA test of Unil Roba, Bibi Sumi and Hotoshi Sumi, which both the parties agreed to comply. ESH then agreed to bear all the expenses regarding the testing. Then this is the documents. Then Dr. Mikali come to page 79. An order was passed there, which was the challenge, In compliance with the Honorable High Court such and such, directing the state respondents to conduct a thorough inquiry in regard to indigenous identity of Bibi Sumi, the undersigned has heard all the stakeholders on 2011-2021 and 4/12/2021, minded the proceedings closed by giving the chance of producing the evidence both thoroughly documentary for better adjudication of the case. The undersigned, on being heard of the petitioner, is not satisfied with evidence so produced. Therefore, it is hereby directed to conduct a DNA test of the following persons. Therefore, it is stated that the above mentioned persons have agreed to undergo DNA testing in Eastern Sumi Ho and to some key free some districts union have agreed to bear the expenses including during the DNA testing. This was challenged, okay. Then next judgment, okay, it's starting from page 80. Malad, this is a judgment 22nd December 2023. Lordship, I am reading from paragraph 12, page 87. Here, I have considered the submissions forwarded by the learned counsel for the parties. This court has considered the inquiry proceedings of the Deputy Commissioner, which was held on 2011-2021 and 4/12/2021. The issue that arises before this court is whether the petitioner can be directed to undergo DNA testing against her will. A special protection is given by the law to the status of legitimacy in India. The law is very strict regarding type of evidence which will be let in to rebut the presumption of legitimacy of the child. Before a direction is issued to have a DNA test, the consent of the party is required in as much as such test is a constraint on the personal liberty interest or cannot be carried out without consent of the person concerned. In the circumstances where other evidences are available to prove or dispute the legitimacy, the order for DNA test should be refrained from in as much as such this infringe the right of privacy and also have nature social repercussion. This Honorable Supreme Court in such is held. In circumstances where other evidence is available to prove or dispute the relationship, the court should ordinarily refrain from ordering blood tests. This is because such tests impeach or right of a privacy of an individual could have major social repercussions. Indian rule means toward legitimacy informs upon posterity. The presumption in law of legitimacy of the child cannot be lightly repealed. For instance, in such and such case, it is held. The blood group testing is a perfect test to determine questions of disputed paternity of a child and can be relied upon by courts as a circumstantial evidence. But no person can be compelled to give a sample of blood for grouping test which against his will and no adverse inference can be drawn against him for his refusal. Blood group testing is a useful test to determine the question of disputed paternity. It can be relied upon by courts as a circumstantial evidence which ultimately excludes a certain individual as a father of the child. However, it requires to be noted no person can be compelled to give sample of blood for analysis against his or her will, and no adverse inference can be drawn against her for his refusal. The learned counsel for the respondent number 6 has taken a preliminary objection that Eastern Sunni who are not led parties, therefore the court writ petition should be dismissed on the ground of non-joined parties. However, on the consideration of the merit of the case involved, this court is of considered opinion that not making Eastern Sunni Ho and Sunni Student Union as a necessary party would not be fatal with the petitioner. Accordingly, the preliminary objection is rejected. Thus, the observation made in the present writ petition, the court is of considered opinion that the Commissioner Kifri can come to a conclusion on the basis of the inquiry held on 2011-2021 and 4/12/2021. As this court intends to remand the back to Deputy Commissioner Kifri to take a decision on the basis of materials available in the inquiry proceedings, this court refrains from making any observation with regard to the oral and documented evidence produced before the Deputy Commissioner Kifri. Accordingly, it is directed that the Deputy Commissioner shall come to a final decision on the basis of materials available on the inquiry proceedings here and such without directing Mr. Hotoshi Onurava to undergo DNA testing. In that view of the matter, the review order such and such by the Deputy Commissioner addressed to the petitioner are set aside in wash. It is directed the Deputy Commissioner shall give his decision within the period of 3 months. Then, Lordship. Then, my Lord, during the pendency, page 92, the private respondent was selected by the second NPSC examination by a result dated 15 November 2022. His name appears at page 94, serial number 33. PQ2H. So, my Lord, thereafter, my Lord, it was submitted before the court that he has decided to accept the subsequent offer result, and he did not contest.
Koto is a resident of Kosi or Koto is a resident of which district?
Who, Lordship?
Biological father, according to you?
My lord, the biological father is originally he hails from Yangzidang village of Tifri. That is his original native village. Then he was a border servant, so he was posted here and there thereafter. So, my lord, the indigenous certificate and backward certificates has to trace back to the native village of the father.
Photo se Sumi.
Yes, Yangzidong village of Kifri district. That's why, Lordship, the Kaungraj and the village council chairman and the villagers of Yongzidang were also called for evidence before the deputy commissioner successively.
She claims to be from which community?
Sumi
Sumi.
of Kifri district. Because
Sumi are largely prevalent where?
Zoniboto, then in Dimapur area, Lordship, but then, Lordship, the indigenous inhabitants of Sumis of Kifri are considered as economically backward and they have certain reservation in the Nagaland Public Service Commission. So, my lord, for a person to be eligible, the
Sumis from Jonebutu are backward?
are
No.
forward tribes. They are not entitled for reservation. Only Sumi, indigenous inhabitants Sumi from Kifri district, Lordship.
Hmm.
Then, my lord, the imbue order at page 96, in compliance to the direction of the single judge, this is the order bus. Mary Lordship. This is a summon order issue. My lord, I'm not reading the summon orders. Then, imbue order at page 98. May 2024, Mary Lordship. In compliance to the Honorable High Court of Bench dated 22nd December 2023, passed in 2011-2022, the matter is taken up for disposal according to paragraph 17-18 after 17-18-19 of the judgment order dated 22nd December 2023 as reproduced below. Lordship, kindly allow me to skip this because we have read. Then, my lord, minor cell done. Lordship, if Lordship might kindly see kindly annexure A, then and then my lord, in verbatim, you'll Lordship will kindly see till page 104. All the evidences taken on 2011-2021 and 4/12/2021, which Lordship has referred was produced in verbatim by the Deputy Commissioner in the imbue order. Kindly allow me to skip because it will be only repetition. 104, Lordship. After having all the stakeholders involved with the case, the district magistrate decided to conduct DNA test, to which both parties agreed. DNA agreed to pay all the expenses regarding this case. In view of the above, the present case was taken up for final disposal on the basis of the inquiry proceedings held on 2011-2021 and 4/12/2021, and the materials available in the inquiry proceedings. This case goes upon the filing of a complaint by the Kifri district and some Sumi Students Union to nullify the indigenous certificate issued to Ms. Louis Sumi as she does not belong to indigenous tribe, Sumi tribe of Kifri district. And carefully going through the inquiry proceeding in meeting minus dated 2011-2021 and 4/12/2021, numerous inconsistencies and contradictions were found and detected in the statements given by the witnesses. Therefore, as directed by the Honorable High Court, this office revisits the material available under the inquiry proceeding before this office to come to a conclusion. Among the materials available as referred in the inquiry proceeding before this office, the pension of Unil Rava shows Srimati Ivuli wife, Kavituli daughter, Ms. Divi daughter, which indicates that Divi Sumi is daughter of Unil Rava. Though Unil Rava is in the inquiry proceeding dated 4th December 2021 had stated all has stated all the pension works were done by his wife. As per Yevgeny, she stated that Lady being her adopted daughter was entered as a nominee since she was advised by some officers to enter the youngest in the family. The statement by Yevgeny cannot be accepted without any proof of evidence. This office is detecting the irregularities in the statements and documents available is of the view that all records indicate Devi Sumi to be the daughter of Anil Rova and Yevgeny. On this, in the inquiry proceeding on 2011-2021 and 4th of 2021, Devi Sumi Vituli Yoto such and such stated that Devi Sumi is the biological daughter of Otoshi Somi. On the other hand, another president, Kokodo Yutumi and Hoiko Electronic stated that Devi Sumi is the daughter of Anil Biyuvili and Anil Roba. The statement that Nikitu and Tianado reveals that there was several complaints about the indigenous identity of Devi Sumi, and as the Yangzheng villagers were also confused, representations were submitted to the government. In the inquiry proceedings on 4th of 2021, Hotoshi has stated that he is also known by the name Zihivi. The pension papers of Hotoshi does not name Miss Devi Sumi as one of the nominees, which creates a doubt that Devi Sumi is the daughter of Hotoshi Sumi. Also in the inquiry proceedings dated 2011-2021, Hotoshi Sumi stated that Kavituli and Devituli are not his biological daughters, but the daughters of Onil Rova and Simon Aumi, uncle of Devi Sumi, stated Hotoshi has been mentioned as the father of the Lovituli and Kavituli in this ST indigenous documents are Lovituli and Kavituli because Onil Rava has been adopted by Hotoshi. From this, it is made out that Hotoshi has entered his name as father of Kavituli and Devituli, knowing well that they are not his biological daughters, but are daughters of Onil Rava. Record shows that this office, by an order dated Kifre 16 June 2020, has cancelled the indigenous certificate issued by Levi Sumi, Kavituli and Navituli being children of Onil Rava, as there was a doubt in the credibility of the indigenous certificate. My lord, this is the first order which was challenged, which is being referred to 2020, which was decided on the basis of pension documents. It is pertinent to mention that inquiry proceedings dated 4/12/2021, this office decided to conduct DNA tests of Devi Sumi, Onil Rova, and Hotoshi Sumi, to which the parties agreed to comply. However, the DNA test could not be conducted as the Gauhati Higher Kohima bench by order dated 22/12/2023 has quashed and set aside the order dated 4/11/4/2022 directing them to undergo DNA tests. As such, the remedy available before this office to determine the present case is also exhausted. To conclude with, it is held that the inquiry proceedings dated 2011-2021 and 4/12/2021 does not provide sufficient evidence to show that Devi Sumi is the daughter of Hotoshi Sumi. The documentary evidence also shows that Onil Rava is the father of Devi Sumi. Therefore, from the above observation made in the inquiry proceeding dated 2011-2022 and 4/12/2021, the materials available in the inquiry proceeding, it is arrived at the conclusion that Devi Sumi is the daughter of Onil Rava and Yevgeny, not the biological daughter of Hotoshi Sumi. This is the finding. Lordship, since your lordship is asking for some documents which with regard to Malad executive notification with regard to Indigenous and backward. May I bring one of the letter to visit on Thursday so that I bring all these notifications?
What will be the scope of this jurisdiction regarding determination of facts by the Deputy Commissioner?
My lord, this is the third.
Because we do not sit in appeal.
My lord, I understand. I don't understand.
What will be the scope of interference or scope of judicial review regarding determination of findings accorded by the Deputy Commissioner,
Lordship,
who is otherwise has the jurisdiction and authority, and also as per the direction of the earlier end,
Lordship,
has been vested with the task to determine the facts
my lord, my respectful.
and to record his
Yes.
findings.
It's a very pertinent question. My respectful. My lord. My lord, on the first occasion.
We will not substitute the views.
No,
We can only interfere with the findings to the limited extent of judicial review.
Lordship.
Right? We are not going to substitute the
No.
findings. So on that basis, you have to make submission.
Lordship. Yes.
Right? But At the same time, this backward class and indigenous inheritance certificate, the source that I want to know.
So, my lord,
Okay.
let it be as ordered so that I produce two documents because that will as desired by lordship, that has to be produced. We have not brought the qualifications today.
Then we'll find out the scope of judicial review.
Yes, lordship.
If it is in a decision-making process, something is there,
My lord,
you can interfere. But we will not substitute.
no. Lordship, we kindly appreciate the fact. I will try to satisfy lordship on Thursday, but at the point.
No, I'm open, I'm just
Yes.
asking some queries does not mean that I have
really appreciate.
formed my view.
Really appreciate lordship. Lordship.
Whatever is coming to my mind, I'm been asking you spontaneously.
No, the question is, lordship, certain direction has been issued by this honorable court that
Yes.
the letter deputy commissioner give the finding on the basis of the evidence. Now, my lord, he has given the reasons. My lord, he has given in the last two paragraphs, he has given the reasons. So I'll be confining to that, the reasons given by him on the basis of the evidence, not on the those facts. Whether reasons given by him in the review order.
If it is perverse, yes, it can be
Yes,
tinkered with.
yes. So I'll be confining to that reason, sir. I appreciate that.
Sufficiency or insufficiency of evidence to reach the finding is not within the scope of judicial review. Sufficiency or insufficiency, he has some material, he has reached a finding, we are not. But if it is perverse, yes,
Yes,
then
lordship.
subject to your more submissions from your side.
Lordship. Lordship.
Mr. Jamir, you are praying for whom?
In BSc.
I'm appearing for NPSC. So far as the role of NPSC is concerned, it is like a post office.
Right.
To send recommendation, requisition, we advertise, and then we will declare the result, and then we will send recommendation. If something goes wrong, this honorable court may again give some direction, we will comply with that.
Okay.
So
Okay.
we are acting like more or
Okay.
less like a post
Okay.
office.
So basically, the contestant is gone.
Lordship.
Now you are facing the states.
Yes.
The private person has gone. He has joined a post.
Other issues are there. The prohibition of my post, that is one aspect. The second part is since 2019. In view of the cancellation, I'm sitting in idle at home, I cannot appear in exams. Last 6 years, I'm just sitting at home. And that is also another aspect of the government side.
Huh?
If you guys go up the Indian orders,
Huh.
I think it is the government, okay.
Okay.
So there will be a contract, if you are starting
Oh, it will be.
tomorrow we division, don't you? The basic tomorrow is Wednesday.
Thursday we have division or Wednesday?
Wednesday. Tomorrow is division page normally on Wednesday.
Thursday then?
Lordship.
Okay. Third Mr. Takamasal and Senior Counsel for the petitioner. Mr. C.T. Jeremy and Senior Counsel for the respondent NPSC and Mr. Kiva from State Counsel for the state respondents are in attendance. This is the case on Thursday.
As part of
Okay, perfect.
much of life. That's much of.
But I'm not very accustomed with the laws of the state of Nagaland.
Lordship, I was under the presumption, that's why I did not want to stop here, I'm sorry. Lord.
And this, so far otherwise also, indigenous inheritance certificate and backward class or type certificate. I have no knowledge about it.
Yes.
And so far as reservation also, it is so complex. A reservation and caste certificate is so complex.
Well, here,
Because to be frank, Honorable Supreme Court also got itself confused something.
in this case, once the indigenous certificate of the petitioners is cited, then the other issues become automatic.
No, your indigenous certificate, if it is, say, affirmed, then backward tribe certificate will stand.
Yes, as well as scheduled tribe.
As also scheduled tribe.
Yes.
Okay. Let's see.